All right. Yes.
Okay, okay, yeah, just give it 30 seconds.
Okay.
Oh, I hear someone arriving.
So, waiting for a friend.
Hey, how are you?
Right at kickoff.
Ta-da.
Yeah, right at kickoff. What do we have? 1, 2, 3, 4, 5.
What's up, everybody?
We're gonna need one more. Before, all right, we. Yeah. All right. Steve, you think we should start, or?
If you want to. Yeah, you can give, you have to go through the oaths,
Yeah. Okay. Well, one of them.
Except
isn't here.
he's not-
Yeah, Vincent's not here.
and he needs to be
He
appointed.
needs to be appointed. We need him. Yeah. All right. Okay. Just bear with us 1 minute. We're waiting for one more member to get in who needs to be sworn in. Yeah. Yeah. Everyone replied yes. Probably. Oh. Hey. Okay, Vincent's here. You're right there. That's your new seat. Yep. Excellent. Okay. I call to order the Borough of Oradell Zoning Board of Adjustment meeting, reorganization meeting for February 18th, 2026. Notice of this meeting was published in the official newspaper, prominently posted in Borough Hall, and filed with the clerk's office in accordance with the requirements of the Open Public Meetings Act. This meeting is a quasi-judicial proceeding. Decorum appropriate to a judicial hearing must always be maintained. Any questions and comments must be limited to issues that are relevant to what the board may legally consider in reaching a decision. Welcome back, everyone. Happy New Year. Let's kick off with the Pledge of Allegiance.
You have to do oath of office first?
Before Pledge of Allegiance?
Yeah.
That feels weird. All right, sorry.
You got the agenda?
Yes, all right. Sorry, false alarm. We'll get back to it. Oath of office. So I and Vincent are up for renewal, so we'll repeat our oath of office, then we'll get into the Pledge of Allegiance.
Do you want me to do you together or separately?
I think together's fine. It's the same oath, right? Yep.
If you could both raise your right hand, and if you could just repeat after me. I, and then state your name,
I, Chris Antoniello,
do solemnly swear or affirm
do solemnly swear or affirm
that I will uphold the Constitution of the United States
That I will
uphold the Constitution of the United States
and the Constitution of the State of New Jersey,
and the Constitution of the State of New Jersey,
and that I will bear true faith and allegiance to the same
and that I will bear true faith and allegiance to the same
and to the governments established in the United States and in this state,
and to the governments established in the United States and in this state,
under the authority of the people,
under the authority of the people,
and that I will faithfully, impartially, and justly perform
and that I will faithfully, impartially, and justly perform
all of the duties of the office of,
all of the duties of the office of
and if you could state your position.
Zoning Board of Adjustment member.
What class, do you know what class member you are?
I don't. I
Four.
don't. 4?
They're both 4,
I think
right?
we're all 4, yeah.
And then you're with a term expiring,
With the term expiring, I believe it'll be 2028.
The term expiring 2028. It's a zoning board class 4 member.
according to the best of my ability, so help me God.
According to the best of my ability, so help me God.
And then you'll both sign, and then I'll notarize.
Okay, thank you.
Do they each have one?
We don't up here.
Yeah, you can, you put it on both.
Okay.
The names are both on there. You don't have to notarize it if you don't want to.
I can notarize it.
Thank you.
Congratulations. Congratulations.
We're just sign right here? Okay.
You both sign on it, and then I'll notarize.
All right.
While you're doing that, I'll do roll call.
Okay.
Mr. Lau?
Here.
Mr. Bartlett?
Here.
Mr. Devine?
Here.
Ms. Odinsky?
Here.
Ms. May? And Ms. Day?
Here.
And Mr. Santaniello.
Here. All right. Here you go. Okay, sorry, a little disjointed. Pledge of Allegiance. Now we can do it. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All righty. All right. We're underway. Let the record show that Mr. Camporeale has arrived, and we're a full board tonight. Excellent. Okay. A little bit of business to cover. Since this is our first meeting of calendar 2026, this is our reorganization meeting. So we need to re-elect chairperson, vice chairperson, and secretary of the zoning board. Does anyone have a nomination for chairperson?
I'll make a nominate that Chris continues as chairman of the board, chairperson of the zoning board for 2026.
Thanks for your confidence. Does anyone have a second?
Second.
Okay. Thank you. Do we need a voice vote
All
or?
in favor?
Aye.
Any against?
Thank you. Hopefully I'll continue to do an okay job. Nominations for vice chairperson of the zoning board. I would like to nominate Tom to continue on as vice chairperson for this year. Is there a second?
Second.
Okay.
Who is that?
Carl.
Second. All in favor?
Aye.
All against?
All right. And for secretary, do we have any nominations? I would nominate Jeanette, if she doesn't mind, to continue on as secretary.
I second.
Okay.
All in favor?
Aye.
All against?
All right. Thank you.
That was an easy vote
That was easy.
for everybody, for you guys, right? We appreciate what you've done. No need to shake it up.
Thanks for the confidence. Moving on, appointment of counsel, CSG Law. I'm not going to try to pronounce the names because I'll get it wrong because we're on the air. But CSG has been our attorney for the zoning board for 2025, and I would say that unless there's an objection, I'd like to renew that. Is everyone in agreement there?
All in favor?
Aye.
Any denial? None?
Excellent.
Thank you very much.
Thank you, Danielle. Appointment of engineer. Okay, so David Atkinson has been with us for zoning and planning from Negley Engineering. I see we have a substitute today. Hi, what's your name?
Allie Tierney.
Hi, Allie. Nice to meet you. I would propose that we renew. Any objectors?
All in favor?
Aye.
Any against?
Excellent. Thank you. Appointment of planner, Caroline Ryder, again. Thank you for being here. T&M Associates. Again, I would suggest that we renew. Any opposed?
All in favor?
Aye.
Any against?
Thank you very much.
Thank you very much, members of the board.
Thank you.
Thank you.
And appointment of recording secretary. Gabby's not here tonight, right? No. Okay. But Gabriella Ferreza, she has been in the office keeping us up to date with our minutes and all the other administrative purposes for everything that we do here. I would recommend we renew her contract. Is it contract or appointment?
Appointment.
Appointment, okay.
And she does an excellent job.
Yes, that she does.
All in favor?
Aye.
Any against?
Okay, thank you. Zoning board minutes. So we have zoning board minutes from December 15th and January 21st. I believe everyone received them via email. I don't think they're printed out here, but you would have had a chance to review them. Any review comments or changes needed? Do we have a motion to approve zoning board minutes from December 15th and January 21st?
I'll make a motion that they both be approved.
Okay, do we have a second?
Second?
Okay, all in favor?
Aye.
Opposed? Okay, the minutes are adopted. Correspondence. Let's see, do we have a lot this month? Correspondence, as always, is available on file in the Borough Construction Official's office. Okay. Zoning Board procedures. Couple of new faces, so I'll go through it quickly just in case. The Zoning Board is a forum for property owners to apply for exceptions to local zoning ordinances. If what someone would like to do with their property isn't something the building department can approve, they can seek a variance via this process. The way we conduct these meetings follows the procedures laid out by the New Jersey Municipal Land Use Law, and that's what determines what can be said and when it can be said. Thanks in advance for your understanding and cooperation. Excellent. Okay, no new cases will be started after 10:30 p.m. We will look around 10:30 p.m. for a logical break point to push and continue at the next meeting. Okay. Last easy one, memorial of resolutions, calendar 825-17, Christian Brothers Institute, also known as Bergen Catholic. This is a resolution to extend their approval from 2017. Does anyone, do we have a motion to adopt this resolution? Right?
I'll make a motion that the resolution is adopted.
Okay, thank you. Do we have a second?
Second.
All right. All in favor?
Aye.
Any opposed?
You have to do roll call.
All right.
And Mr. Chairman, if you want me to go back to number 8,
I'm sorry?
wherein
Oh, sorry. Yes, if you don't mind.
if all the professionals could raise their right hand. Do you swear or affirm that any testimony you're about to give tonight is the truth, the whole truth, and nothing but the truth?
I do.
Thanks.
Okay. Vincent, can I get that pen back?
Sure. Yeah.
Oh, thanks.
The official thing.
This is only
All right. So, yes, yes, yes. No longer here. Yes, yes, yes. Yes. If you don't mind. There you go. All right, we're on calendar 891-25. This is 505 Kinderkamak. Yes, it is. Okay.
Excuse me, sir.
All right. Could you pass this to Steve? Thanks. Okay. Okay, it's been a little while.
Yes.
Has everyone who is sitting in for this case, has everyone either been present at all the prior meetings or caught up via the recordings, video, or otherwise?
Correct.
Yes?
Yes.
Everyone's up to speed? All right. All yours.
Thank you, Mr. Chairman, members of the board. As you're aware, we were here previously, I think 2 or 3 times regarding this application. It's a request to change the age restriction on the already approved project at 505 Kinderkamak Road from 62 to 55. You've heard testimony from the principal, Mr. DiDio. You've heard testimony from our planner, TJ Ricci, and the legal memos submitted by myself as well as his planning memo. We have nothing further to add tonight. Last time when we were here, there were only 4 members of the board and we weren't able to vote. I believe we also needed to open to the public, but we have no further testimony to put forward at this time. But we're available for questions.
Okay.
And if I may, at
Yep.
the last hearing, Mr. Chair, we did ask Mr. Gilson for additional documentation and a legal memo on the difference between 55 and older and 62 and older. He did agree to provide that at that November 17th meeting, and we have not received anything.
Okay. Is that something that we can still get?
I believe I did provide, since that meeting, an updated memo.
We only received one memo from your office.
I didn't see it.
I don't remember seeing it in email. It's been, I'm not trusting my memory entirely, but you obviously pay more attention than I do. as far as being official.
We have reached out repeatedly and asked for additional information. And there was testimony given at the November 17th hearing that stated there's no difference between 55 and older, and just doing like periphery legal research, there is a significant difference between 55 and older and 62 and older, because 55 and older permits 20% to not have that, it could be in any age. And that's when Mr. Gilson at the November 17th hearing offered to provide a condition that all of the individuals who would be residing there be 55 and older, provided it's legal. And I advised the board that I cannot allow the board to impose a condition not knowing whether it's legal or not. And that's where I asked Mr. Gilson to provide additional legal basis for his opinion. And I also specifically stated, did the board want me to do that research, or is Mr. Gilson going to provide that research? And it was specifically put on the record that it is the applicant's obligation, and he agreed to provide it, and we have not received it.
Okay.
If you just said you provided it, could you present it now? If we have the
Let me look in
document?
my emails if I can find it.
Yeah, if it's something we could review now, that would be useful. Otherwise, I don't remember. I know we took a straw poll at the tail end of the prior meeting. I don't remember where we left off, but I think we were definitely interested in this info.
Danielle, was that the only condition? I remember there was a lot of back and forth, not just of the memo, but was there any other conditions that were agreed to from our past meeting? Because I seem to remember there was one or two items that we had brought up.
They had to provide a lot merger in regards to the property. We went into the basement searching our records, which was difficult. But we do have a deed consolidation from the last application that was presented. So there's no further need for that item.
And I don't see anything else in my notes from those prior meetings. I know there was questions that the board had.
Yeah, I thought we had an open question around the reason for the change in the age restriction. During the application, the applicant had originally proposed a 55 and older requirement, and then during the application process originally switched to 62, and now the applicant's asking for 55, and we wanted to understand what's changed that drove that need that wasn't present 3 years ago when the application was made.
Well, I think as far as that question, I think Mr. Dio's testimony was that it wound up being more difficult than he expected to rent with that age restriction.
So the market changed?
That was his testimony, yes.
So, Mr. Chair, it's either we're going to vote based on what we have now, or are we going to wait and see if we could have the testimony or some sort of condition on what was asked at the last meeting? You know, leave it up to council to decide.
Yeah.
I guess those are the only options.
Yeah, I think. I think we're in a position where there's no further, there's no testimony left. I think, like you said, I think we still have to hear from, public question on the, whether it was public question or public comment. I forget. It might have been.
I think it was comment.
It was public comment, right?
It ultimately comes down to their testimony is that they don't want to provide any further documentation to support the difference between the 55 and 62.
Yeah.
And that
and that's
they want to continue to go forward from here. So.
Well, and that's the concern, because I think the offer, the suggestion was that there be a condition of approval to limit residency occupancy to only 55 and older, but that is where none of us could really be sure if that's even legal, and the board can't impose an illegal condition of approval, which is why we were hoping to get some type of legal verification for that. So absent of that, you know, or the other documentation about the legal standing between 55 and 62, I really don't know what someone would propose. You know, I don't know what motion someone would make. You know, I wouldn't recommend that we make a motion for something we're not sure is legal. Is that a fair assessment?
Yeah, I would not advise the board to condition it on something that I can't even tell the board that I would think that it is legal, because in the event you do condition it on it being 55 and older, and that's an illegal condition, that goes away.
Mm-hmm.
And then it goes back to the 55 and older with the 20% being able to be whatever age. So I think the only option that's before the board tonight is, unless Mr. Gilson withdraws the application on his own accord, is for the board either to make a motion to approve the application or make a motion to deny the application.
Without condition, no condition.
Without any condition regarding the age. So.
Unless the applicant and council decide to come back again and present something before the board decides to vote in that sense. It's ultimately their, I guess, call.
Yeah, you do have the option to withdraw the application, right? Everything that Danielle said.
How about we open to the...
We can do another day.
The only reason why I would caution against that is it's public knowledge that the board, it may be merging. I think it gets a little messy, and I know that the applicant would have to consent to it. So I think we're at a point in the deliberation on the application where a decision has to be made.
Yeah.
There's nothing in the event the applicant wants to withdraw without prejudice. They're certainly entitled to do so, but if he does not choose to do that, I think the board either has to approve or deny it at this point.
Thoughts?
I will discuss with my client. If you want to open to the public while I do that, I obviously don't object.
Okay, yeah, let's have public comment during this time then. We'll open 505 application to public comment around the change of, this is a request to change the age limit from 55 to 62.
And if I could, anyone that gets up, just for the public's knowledge, I have to swear you in because this is testimony. So if you could just raise your right hand, do you swear affirm that any testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
And if you could please state your name and spell your last name for the record.
Okay, Paul Latsunas. I live at 50 Beverly Road, beautiful Beverly Road in Oradell. I was at the last meeting, and I saw that I heard and I watched the meeting, and that we were going to find out the legal reasoning. So I feel that we don't have the legal reasoning, but I have something else to add, and that is the people that are there now are 62 and older. Now, when they decided to take the apartments there, they're 62 and older, I would think that that's what they wanted. So if we lower it, then it's not a fair deal for them. If we lower it to 55, because from what I understand, if you're 55 and you can have a family member there that's younger than 55, and that would be wrong to the people that already got the apartments at 62 plus, and that's what they thought it was going to be. Perhaps they didn't feel that they would want a teenager running around or in the parking lot or something of that sort. So I feel that I can't see how you could pass this way at 55 and younger. And then there's the 20% rule that you mentioned, Danielle, and I think that 20% would be less than 55. And that's not good for the people that are there that are 62 plus. And that's all I had to say. Thank you.
Thank you. Any other members of the public with comment on this case? All right. No takers. We will close public comment. We'll give the applicant a minute to finish up their conversation. Let's see, here they come.
Did I miss anything exciting?
Well, I don't want to paraphrase public comment, but a good point was brought up about the current residents with their understanding of the 62 age requirement and what the impact of a changed age requirement would have on their, I don't want to say quality of life, but their perception of their feeling about where they live.
Understood. I spoke with my client. We're not willing to entertain the condition related to no one in the building under 55, so I think that is moot at this point as to the legality of it. So I think we can...
Okay, so that condition is off the table then?
Yes.
Okay.
As far as to why it was 62 and why we're moving 55, if there's more questions about that, my client is willing to come up and answer and testify as to that. Again, I think he addressed it, but if the board would like to ask more questions about the thought process, but why this was originally 62, he's happy to come up and discuss that.
Board, what do we think? Do we want to hear? Yes?
Tom? I believe he was sworn in, but if you'd like to re-swear him.
I think you're still under oath,
I was going
right?
to say, you're still under oath. You're...
No, I got it.
Yep.
I think the question came up, originally we went for 55, and then the board asked us to go to 62, and so that the process went more smoothly, we agreed to 62. We built the project, and I thought we did a nice job building it, and started leasing it. It's very difficult. So, we have a mortgage to pay, we have taxes to pay, and it took forever to lease the building. 20 units. I finally got it leased. And it's leased and we're doing fine, but it's very difficult to lease 62 and older. And going to 55 is just a way to have more people, because we had so many people call us and say, I'm selling my house in Oradell. I'm, 58 years old. And I would say, I can't rent you the unit because you're not 62. So we came back and thought we could get some relief. And that's why we're here.
And have you had any issues with parking on the site? Could you describe how typically parking is available?
There's no issue with parking. There's tons of parking. If you look at the building on the left-hand side, it's always open. We have no park. We have plenty of parking spaces. I have two EV chargers there, 2 or 3. They're never used. It's pretty quiet.
How do you plan to regulate the occupancy if this is approved favorable? In each new lease an application comes in, the occupant wants to move in, and they have 3-4 different occupants on there. The main leaseholder is obviously meeting the age requirement of 55 and up, and then there are 3 other occupants that are not of the age requirement, age restriction, but are allowed to, be an occupant in the building. How do you know that lessee that's signing for the apartment is actually residing in that apartment? How is that going to be regulated and managed through the building?
Well, it depends on how big.
You want me to answer that, Tom?
Go ahead, Steve.
Every time there is a new tenant, they need to obtain a certificate of continuing occupancy. Within that application, then they would put down who they are, how many occupants in that space, and their ages.
Okay, and then that has to be registered as their primary residence to where they live? Or like how does that, like if I'm signing that lease and I'm gonna live there, me as an individual, I'm not 55, but say I am, I got 3 other houses, but for some reason I want an apartment available in Oradell, and I'm signing a lease that has 4 occupants on there. How is that regulated to know that leaseholder who's qualifying for the apartment at the age of 55 is residing there? That's, I guess, that might be, again, another question. I think what we're all deliberating over, difference between 62 and 55 is not the building turning into a freelance apartment building, that it's still maintained and run as a senior or a age-restricted
Can I answer
complex.
that? I own the building. The value of the building is more important to me than anybody in this room. So I don't let that happen. I run a very tight building, right? So.
But the market speaks to the market. A free-range apartment building that has flexibility that can be leased in 2 different ways, as an age restriction, or can be there's ways to manipulate the lease to open it up to somebody else. That becomes more valuable to a potential investor than, say, strictly one. So it shouldn't really be what it's valued to who individually.
No, I'm not
it's
saying
just
that, Mike.
how the operator runs. So if you're no longer the operator in the future, the next operator, and then the next operator
But by
after
law
that.
today, I do the same thing for 62. I look at who the tenant is, and that person can live here for 6 months in Florida for 6 months. So.
But wasn't the 62, the regulation is that no one else can be on the lease of a lower age. But that's everything we're discussing here is that discrepancy. So if we shift from 62, where we presently are now, you don't need to regulate the different occupancy because you can't have the residents below. Am I correct?
If
So
you're
if we change to
62
55,
and your wife is 61, I can rent it to you. You're 60. I mean, I'm not. That's. I may have tenant there right now. His wife is 61.
but is it we're on additional occupants, right? Like, is it wanted to go to a 3rd and a 4th occupant? Like, not just saying about one, right? They're 1-bedroom apartments. They're 2-bedroom.
No, they're 2-bedroom apartments.
So in the 2-bedroom apartments, do you have occupants of 4? Any right now, or are they only 2?
Most of my tenants are 2.
2. And if we shift to a 55 and up, what's the probability that you'll maintain 2 per apartment? It's probably very low, I would assume.
You're asking me questions I can't answer.
We have to provide the testimony in order to decide on whether or not we're going to grant the variance. So I'm just trying to help for the rest of the board members to understand, how the severity of the shift. That if we're not going to get any additional documentation to support. That at least we can get an understanding of the answer to that question could have been, we have property management on site and we check. It doesn't have to be. It's just an understanding to know that when it goes from one operator to the next operator to the next operator, that the way the building is run doesn't change because there's flexibility in how the apartments are being rented.
I just want to make some clarification on the record, because my understanding of the Housing for Older Persons Act is that no one can live there when you have the restriction for 62 and older, that no one can be under 62. So that's my understanding.
Including a spouse?
Yes. It says Section 13:15-1.4, 62 and over housing. This provision's regarding familial status in this chapter shall not apply to housing intended for and solely occupied by persons 62 of age and older. Housing satisfies the requirements of this section, even though there are persons. There are unoccupied unit. I could provide you this. It's like a whole section, but.
But really, what it comes down to is the change is in a 62 and over building, the occupancy has to be maintained at that age or above.
Yes.
If it changes to a 55 and up, then the leaseholder has flexibility in how they add occupants. There's no restriction. So a 2-bedroom apartment could have 5 occupants. One leaseholder can be 55 and up. The remaining occupants cannot. Now, Not saying that that's a problem or that can't happen. We're just trying to understand the difference between what we have currently right now and what's approved as a 62 unit, 62 and over building, to what the change is actually going to be when you approve to the shift to the 55.
Well, I think all I can tell you is right now, my average tenants are 71 years old.
Currently, but when it changes, when it's a lot easier to rent, that's going to change. Not saying that that's just what's going to happen.
I think that it's also important to note, and I think we've made this point before, I know that we talked about these different acts, but our position is that this age restriction was a restriction placed as a condition of approval related to a municipal land use law approval, that this was not approved as a senior housing development per se, that this was a restriction placed upon the board.
I'm not sure if it was a condition of approval or if it was actually the proposal.
Well, it was definitely a condition of approval, and the condition of approval that we cited in our application contemplates that we can come back to the board to change that condition of approval. So our position is that we're before the board is to change the condition of approval as contemplated in the resolution, that we could come and appear to change that condition of approval. We're not presenting this as that it was a senior housing project or that it was approved under that formula and statutory scheme, that this was a municipal land use approval that happened to have a condition on it related to the house, related to the age upon which the applicants could be. And the resolution specifically says that we can come back to the board and request relief from that condition.
But you still have to, I'm sure,
Have to
make the
present
proofs.
why.
And this application, although I wasn't involved in it, it was, I believe, a D1
No,
use
I
variance.
understand, but that's what I'm saying. I'm saying that our position is that the proofs that put on by our planner were to support that the granting of the D1 variance would not be impaired by the change in the condition, that it's not an issue of the different types of senior housing, but an issue of a D1 variance, and that we've put on the proofs from our planner that the D1 variance granted by this board would not be negatively impacted by the change to 62 to 55.
I don't think anyone here is saying that you don't have the ability to come back and request relief from that condition. I think what the board and what we've been asking is, what are the change in circumstances? What are the proofs that justify the D1 then? What are the proofs that are needed to justify a D1 use variance that haven't been proven, and that when we've asked for additional testimony about the legality of 55 and older versus 62 and older, we're just being told there's no difference. And that's where, while you are entitled to come back to the board and ask for relief from conditions, you still have to put proofs on the record.
Which we've submitted through Mr. Ricci's testimony that there would be no negative impact to the surrounding community and the D1 variance by how the patterns of 62 and 55-year-olds would behave in this project. And that's the proofs that we've put on. The proofs related to the D1 variance itself, not related to how all these senior housing laws impact, because while they're obviously important, they're not the subject of this application. That this application is, we have a D1 variance that was approved by this board. A condition of that approval was that the occupants would be 62 years old. That condition of approval says that we can come back to the board to apply for relief from that. My position is, and my client's position is, that the proofs that we need to put on to satisfy that are that the D1 variance granted for the residential use at this location would not be negatively impacted by the change from 62 to 55, and we believe that Mr. Ricci's testimony, in conjunction with Mr. DiDio's testimony, support that position, that there will be no change, no detrimental impact to the neighborhood as the change in application. There will be no impact, there will not be a negative impact to traffic, there will not be a negative impact to the surrounding community, there obviously will not be a negative impact in the way that the building is constructed, because the building is already constructed. So that's the proofs that we believe we have to submit and have submitted. That it's not an issue of what senior housing laws we're applying and how those laws are applied, that it's simply an issue of, is the D1 variance granted by this board negatively impacted by the change from 62 to 55?
But there's a lot of questions that council and the board have raised about about the age of the residents that lead directly to travel habits and other factors that I don't believe have been answered. The board members have requested it, the board attorney has requested it, and now we still don't have an answer. So I don't understand how there can be how there can be a decision made that there'll be no impact when the board is not satisfied, and quite frankly, neither am I, about who the residents would be. I'm also looking through the resolution, because I remember discussing this last time, the resolution and the planner for the application, for the applicant who testified. And I'm fairly certain there's a lot of testimony in here about the specific age, which again leads to the D1 use variance. There's testimony about.
I think we had a lot of testimony. There was about refuge. I remember where the placement of where the garbage was. There was because it was near someone's backyard, and we talked about amount of occupants, and that's again this changes just the amount of how dense the building is going to be. So I think there's a significant amount of impact, like Caroline is saying, that we're just looking to understand a little bit more.
And I don't want to speak for you, but I think also that the questions that the board has raised and the attorney has raised haven't been answered. Furthermore, when the applicant's planner testified, there was specific testimony given about ages 62 and above and that demographic. And although I wasn't here, I'm going to assume that was a factor in the use variance, in the D1 use variance. So I think these are all important factors.
Board questions? Anyone else?
So, I'll ask it maybe one last time. Mr. Didio, I understand your testimony about the difficulty in leasing to 62 and over versus 55, and I think we can all understand that understand why that would be the case. What I was asking about was a bit different, which is those are facts presumably that would have been known at the time that you and the group made the application, right? What the rental market was, whether it was for 55 or 62, and what's changed in the market between then, which was not that long ago, 2-3 years ago, and now. I still don't understand what's changed.
I can answer that. I'm not a big national developer. I'm a local partners that built this, local to Oradell. We want to do something nice. We were asked to do an age-restricted project. If we had to do it all over again, we would come in for market because it should be open. It's only 20 units. But, we understand that, the limitation on children for older, age restricted. So we decided we would go that direction because we thought we could lease 20 units. But the market told me differently. So the answer is we made a bad call. I'll be honest. If I had to do it over again, I would not build it.
Mm-hmm.
That's fair. Other questions? I suppose we have to. Oh, again.
Yeah, just so I understand. It's an age-restricted building. The age restriction is 62. And you want to make it an age restricted of 55. But am I correct then that you don't have to comply with any other senior laws or anything like that, that if it's age restricted to 55, what does that mean? One person there can be 55? If it's age restricted to 62, does that mean only one person can be there at 62? Because I'm unclear as to, I understand it's a D1 variance, but the way I'm hearing the testimony, unless I'm wrong, you're saying, well, we're here for a D1 variance. I don't have to comply with any of the other laws that are out there because this isn't senior housing. It's age restricted, and if that means there's a difference between age restricted and senior housing, I'd like to understand what that is because I'm just not clear what even the requirements are now. If it's age restricted at 62, does that just mean one person in there has to be 62? We don't have to comply with the senior housing laws or anything else? If we age restrict it to 55, does that mean only one person in there has to be 55? And even forget the 20% rule, because does that mean you're not complying with any of that? That I need to understand in order to consider what it is I'm voting on.
Sure. Well, what I'm saying by that is that the 62 condition is imposed as a land use condition. It's not imposed as a senior housing condition.
Can you break that down, though? Because this is the question that we keep coming back to. Right now, I think the belief, the understanding, whether accurate or not, is that the 62 age restriction on the current building bars anyone under 62 from living there, period. Is that, Danielle, is that accurate, what we believe right now?
That's my understanding. Again, I have asked for additional information. I
Okay.
did not go into a deep dive in it, but my understanding is yes. 62 and older means everyone 100% 62 and older. The 55 and older means 20% of the people can be any age.
So it's not just a change of minimum age of resident from 62 to 55. This board, and I think our professionals, are concerned with 62 to 55 plus whoever 55 wants to move in with them. I think that's the big question. I personally don't think 62 to 55 is a big deal, but at 62 to 55 with 20% whatever, and whoever 55 also has living with them, that's a significant change in use for the building.
Understood. My position is that however it is operating currently, which I believe my client's testimony is, whether that's correct or not, that there are people under 62 living in the building, that will not how it's operating will not change whether it's 62 or 55, because it's not dictated by senior housing. It's dictated by a land use condition that was placed upon by this board. So whether or not that's being done incorrectly now, that's not going to change as a result of a change to 55, because it's not under it was not approved under that statutory scheme. It was approved as a land use condition.
I am confused by that argument, honestly, and if that's the argument you're now making, then I'm also confused why you submitted a legal opinion that included the Housing for Older Persons Act.
Well, because we were asked to by the board, but I still don't contend that that's the correct way that this should be analyzed. But for the board's benefit, we did provide that analysis. But it has always been my position that this is a land use condition, and we are appearing to have that land use condition altered, and that the standard that we need to meet is that the D1 variance that was granted by this board for the residential use will not be negatively impacted by the granting of the change to 62 to 55.
Okay. I don't know what else. I don't know how else to dissect this, to be honest. Am I overlooking anything? I suppose we had a little more testimony, so we have to open it for public question.
Question and comment.
Question and comment.
You could do it together.
Do it in one. Before we do, any other board? So here's my thoughts. Stop me if someone disagrees. Check with the board. We'll open it for public question on the additional testimony. Comment again, because we're ending again. We'll conduct a straw poll, and we can ask for a motion based on, I still wish I understood whether there's a difference, a legal difference between a condition of 62 and 62 senior housing law. I don't know if the two can be separated. That's me not being a lawyer.
I kind of would just still want to know a little bit about the leasing process, how it's done now and how it'll be done in the future. If how lenient the restrictions are to qualify for an apartment. If it moves favorable, the application, is there a way to require residents to make sure that at least is their primary residence of occupancy as some sort of a, as an owner needs to fulfill this, as have some sort of obligation? I know it's going deep in there, but I didn't even get an answer really to that question of how that would be regulated, because that's something that's important. If it's changed, we understand there's risks to owning the building, and you don't want it to suffer. But we also don't want to grant something that just then kind of eliminates the whole notion of the previous application that it was an age restriction, and now it just simply is a basis of it was a land use. So we, instead of granting the application that was presented previously, it's now we're changing it for a third time. So that's something that I think is just important to know how the leasing will be handled if it's going to be favorable, how the understanding who's signing it and who's obligated to the apartments, and how that's handled. Is it direct to the owner? Who's
I mean, I can tell you how we lease the property. Everything comes through me or my partner, and we meet every tenant, and they do credit. We do credit check on them. We see where they come from. We decide if they qualify, and if it's yes, they qualify. Then we get them a very lengthy application. They fill it out, fill out the credit report, and then.
Do you know? Is there any follow-up? Is there any part of the application to know whether or not like that residence that they're signing off for, and this would be for if we shift the age, is that it's specifically going to be used as the primary residence for that leaseholder?
Yeah, we know where they're coming from. We know a lot of them come here for the summer, and they go to Florida in the winter. We have tenants that, so we have. Yeah,
so
we know.
You could sign the lease. Say you're going to live there, live in Florida, go there for 6-8 months, and then the occupants of that who are not age restricted have access fully to the apartments if we shifted it from 62 to 55 in that scenario. Correct? So, unless there's you mentioned that if the apartment is left, and you're not residing there for more than 3 months or more than 6 months at a time, you can't add other occupants to the lease. These are certain things that change the difference between a building going from free market to having the age restriction.
There's just no way that I could manage that. It's like how do you restrict the person's
No, it's just asking questions,
come over
just
and stay for
understanding.
the weekend.
Yeah.
I mean, I can't run. I can't manage that. But
Just
we're very,
understanding
it's
the
very,
intention of
we're very strict. It's hard to rent from us because we make sure everybody can pay the rent, and they're good people. We check on their history. We see where they come from, and we do what good owners would normally do. We don't want to get anybody in there that's not paying us and not being able to support the rent.
An example is that the World Cup is coming around. There's people that use Airbnb, and they can have a lease onto this apartment, and they're living in Florida for a certain period of time, and they got one bedroom available because their 18-year-old son or daughter is living there, and they decide to what, this is a good way. We're going to rent out the other room for something like that. That these type of things happen, and when you're changing how a building is regulated and stripping it from what was initially granted, these are the impacts that us as the board we're just looking to understand that if we vote favorable, that these are the impacts that are going to happen. It's not the building won't operate the same as it operates today if we change the age of the use. You as the operator could want that, but you've testified to us that if you maintain the building the same way, it doesn't make enough money and it's not going to survive. So it naturally will change with the rent going up, and if you're going to have to increase the rate of rent.
I didn't say that it's not making enough money and it won't survive. I said I have a hard time leasing it. That's all. I didn't say it's not I pay the taxes every month. I pay the debt service every month. I pay the operating expenses every month. I'm just telling you that it's very difficult to lease. That's why I'm here. It's not like the building is not.
But it's leased right now, right?
It's leased right now.
Yeah.
But it took me 2 years to get it to lease 20 units.
Mm-hmm.
It should take us 2 months to lease 20 units if it's a market project. And I finance lots of projects in New Jersey, and I own other projects in New Jersey. If something like this was new and that was market, I would have it rented in 2 months.
But as you said, I wish the application we voted on was a market application, because it would have been a lot easier to vote then on the basis of the testimony for the market project than to shift and change now midway through after we deliberated over what we anticipated was going to be an affordable project, an age restriction project, and now we're just asked to change it off of one clause because it was hard to lease. And now we understand that, and we want to work on it. But that's the reason for our questioning, and to just try to get a little more information.
Any other board or professional questions before we open it up to the public? Guidance, topics? Okay. All right. Let's open it up. If there is any additional public question or comment, questions have to be for this recent new testimony only. Comments can be at the application. Please just give us a heads up as to which you're doing.
And can you just state your name again for the record, and you're still under oath?
Paul Tsunis, 50 Beverly Road, beautiful Beverly Road. Whether it's a question or a comment now, I'm not sure. When you made this D-variance, I believe, and I think I remember that people were saying that they wanted a place for 62 and older. But what we were providing for the community was a special place for these people. This is what I think was why it passed that way. Because the community wanted this, to have a safe haven for people that are 62 and older, rather than to have mixed. Now, if you wanted to have mixed, you would have to, you could turn them into condos, and then there won't be any age restrictions at all, because you can't discriminate at that point. And Tom Devon's not here. Well, anyway, I think that there is something that I read in a blog, and it said that if they were like condos or owners, you could not discriminate for age. But this is not the case. This is not a condo. Okay, so in this particular case, it was going to be provided to have a safe haven for those people that are 62 and older. And I understand it was said that you had one vacancy, and it took you a while. Well, when you open any business, it takes you a while to establish the business. You know, so I don't think you did any. You know, I think that would have happened. You weren't going to get 100% right away in any business that you open up. So I can't see any other reason. And if you only have one vacancy out of 20 or whatever it is, 25, how many apartments are there?
20.
20, okay. One vacancy out of 20, and it changes. It gives you time to fix the the apartment up, to do whatever you want to do for the next person, and that's the way it usually works with landlords and tenants, from what I understand. So like, the main thing is a safe haven for those people, and
All right, that's noted.
and if they came to get those apartments that way, then if you change it, then I would think that breaks the lease for everybody that are there. Thank you.
Okay, thank you. Any other public comment or question? All right, we will close public comment. That being said, the only thing we can do now is just board deliberations. So let's kick it off. Maureen, do you want to kick us off? Share your thoughts?
Yeah, sure. So thinking about this and appreciate the situation that the applicant is in, understandable that it is taking longer to lease at 62 and over versus 55. That's logical and rings true. To me, the thing that I keep coming back to, which is what I've been asking about, is the applicant came before the board not too long ago, put forward an age restriction of 62, knowing what the market was for 62 versus 55, and listening and reading, listening to the testimony at the time, and thinking about the use variance that was being asked for. A big selling point of obtaining that use variance was that the property was going to be restricted to 62 and older, a population and a demographic of people that, want to stay in town, maybe don't want to, keep a house here in Oradell, and that this would be an opportunity for people to stay in the vicinity and age in place, if you will. As a senior, 62 and over, very close to 65 as compared to a 55 and over community. So that was a very material part of the proposal based on what I listened to at the time. I wasn't on the board, but I went back and listened to the meetings. And because it's material and I really haven't heard what's changed in terms of the market, what was known at the time or knowable at the time, I'm not in favor of this moving forward as you've proposed right now.
Thanks. Carla?
I think initially the difference between 55 and 62, as I was thinking about it, wasn't that big a difference, but my problem is reconciling what this building is, what laws it's supposed to be in compliance with. I understand the use variance, I understand what was done here, and I respect the fact that your client has the ability to come back and request us to reconsider. I don't have a problem with any of that. But as it stands right now, I would have liked to have had more information in order to better understand what, I can read a resolution, I can hear the testimony about 62, but in listening to our own experts, I don't know what laws are being complied with or not complied with here. I understand you're just asking us to give an age. Well, giving an age has certain ramifications beyond just us saying you can have somebody here at a certain age. I really wish I had more information, to be quite honest with you, because I honestly don't know at this exact moment which way I would vote, but I know that I don't feel comfortable without having more information or more research that I'd like to see before making a decision.
Jeanette?
I guess, I'm also concerned. I mean, I was on the board at the time, and I do recall it being a selling point that it would be addressing an unmet need in the community, that we would have housing for people that were older in the community and 62 and older. I don't know why that number was put out there, but it seems to coincide with something that's out there in the law. 62 and over is a special number, and then 55 is also a different number. And to your point was, well, it's a condition of the approval, but then we could have said, well, if that's just it, that was the only basis, then we could have said, well, 55 and older, and only 55 and older. I mean, we could pick 58 and older. I mean, why was we 62? You know, what was so special about that number? So there is a reason why it was out there, you know, in 2021 and proposed. And I think the board relied on that understanding that it was going to be senior housing and not change to something else in the future. I mean, I just, you know, the 55, like I said, if it was just a number, we could have picked 60 and over or 58 and over.
Well, like Jeanette, what you said, we could have just deliberated over a free market application and been able to look to make sure the building would facilitate that type of use. And now we're forced to make a change that now it leans on the operator, present and future, to trust that they're going to maintain the one clause of just needing one leaseholder to have the 55 and up restriction. Outside of that, any operator can run that building however which way they would like, without really, then the building could sustain it. It's got, ample parking. Not saying it can't do it, but it's just the building we approved, we focused on 62 and over, assuming 1-2 occupants per apartment, to now the building's going to be it's going to be operated differently. The residency is going to shift and change over time, and it would have just been nice to have seen that building and worked on that than working backwards. I think that's really my issue, but I understand that the applicant has that opportunity, has to provide enough burden of proof that it isn't that negative of an impact to just shift. But I think there is going to be a big change in just how that building runs, but we just don't know the extent of it. That's pretty much what I have to say.
Yeah, I think so.
Did you have anything else before?
No, nothing else.
Okay. Vincent?
I feel that I don't have enough information to assess, or I'm not totally convinced that going from 62 to 55 plus with 20% is like a zero impact change. And while saying that, I do feel that 55 plus strictly, in my judgment, would be amenable, but only given that the board is legally able to grant that condition, approval on that condition, which we don't have. Also, I thought Jeanette brought up a good point about the previous application where presumably one of the positives, like when weighing the positives and negatives of an application for the D-use variance, that the unmet need of, say, age-restricted or senior housing must have been heavily weighed in that, and then minimizing also the negative impact due to the age restriction. So while a market rate apartment would be, I don't think there's any questions as to whether that's legal or not to approve. It does seem like the balance of pros and cons would lean heavily towards the cons in that case. So I would not be amenable to that. Lastly, I feel like at least my understanding is right. So the market rate, to expand on that, market rate housing satisfies like not going against any anti-discriminatory laws. And the Housing for Older Persons Act is relief from the anti-discriminatory laws given to like the two narrow categories or something, and I believe that's why we have the 62 number and perhaps 55 number. So that's how I'm thinking about this.
Okay, thank you. Yeah, and I won't repeat everything that the board said, but I think, the theme is, I think we all wish that, and me certainly, wish we had more information just around the extended impact of 62 to 55. I have endless empathy for the ability to rent the units with the difference between those two ages. But it sounds like the board and the professionals just wish that there was more information available, really highlighting the impact of what we'd be voting on. So we don't have a lot of options from here. So
We'll withdraw the application.
Sorry?
Withdraw the application.
You're going to withdraw the application? Okay. All right. Understood. I appreciate the time that you spent explaining to us. As you know, it's not a secret. There's a likelihood that the board will be different the next time around. So we might be a combined board. If you choose to reapply or resubmit this application in any format, it might be with a different, a modified form. I don't know what the timing of that might be. I just want to ask Danielle, do we have any formalities that we must address? They have withdrawn the application.
Yeah, I think there is a concern that any work that's been done on this application to date, that they pay any outstanding bills and that they'll withdraw it without prejudice, but that any outstanding bills and bills being submitted for the work that's being done get paid. So that's the only.
Okay.
There's an escrow with the town.
Yeah, that's what I thought. We just wanted confirmation.
Okay. All right. Thank you very much.
Do you have to make a motion and approve the withdrawal?
I
I'm not sure that we have for
don't think
prior
you have
withdrawals.
to.
If we feel, I mean,
If we were
don't have a
dismissing
choice.
it without prejudice, we would. But because it's coming from the applicant, I don't think we need to.
Right. I feel like we've had recent withdrawals where we didn't. So thank you.
Thank you.
Okay. All right. Being mindful of the time, let's take so we don't get started with the new application and then go into a break. Let's take a 10-minute bio break. We'll come back at 8:42. Let's come back 9:45. Sorry, not 9:40. 8.
It's a long break.
Wrong column. 8:55. Thank you. 8:53. I realize I should have said 8:52 or 8:53, but it's 55, so I'll honor it. 2 more minutes.
All right.
We never get back before the end of the break. Maybe I just gave too long of a break. If everyone's in place, though, we can start. Let's see. We have everyone up here, all our professionals, applicants in place. Sam is there. Can we go, Sam?
Yeah.
Okay.
Yeah, yes.
Okay. All right. We're back from the break early. Look how efficient we are. So calendar 894-25 Golden Care Therapy. This is a continuation from a couple of meetings ago. It's all yours.
Thank you. So, good evening, Chairman, members of the board. For the record, Benjamin Wine of Prime 2 Bell and Maselli.
Yes.
Do you want to make a comment first, or does the attorney want to make a comment?
We can. Actually, I neglected to ask, just because it has been a couple of months, everyone is up to speed on this case as well? Either present or watch the recordings? Okay. All right. Just had to check that first.
One more item of housekeeping as well. I just want to mention for the record that since we had been carried with preservation of notice to the January meeting, and the January meeting never happened, we did renotice for this meeting. And I just want to put that on the record.
Thank you. Okay.
You want to make a comment?
I didn't know if you wanted to make a comment first on the correspondence we received, or if you want me to.
Okay, I will. I just want to clarify something in regards to differences between zoning applications, municipal land use law, and borough codes and building department. In regards to what I oversee is the International Building Code. It's the New Jersey edition, 2021. And in it, it states requirements for what type of uses, properties have or tenants have. And in that clarification, and I've sent it through the emails through the attorneys and so forth, and it's considered an I-4 use, which lists a child daycare center. That being said, the board, and Danielle can speak about that. The board can make a decision on what they want for the property, but when it comes to, say, an past approval, then it comes back to the building department in regards to construction of the space, and there might be some changes because it's considered an I-4 use, but that would be after the fact, after the board and the application is determined.
And just to piggyback off that, Steve's exactly right. I just wanted to make it clear to the board that in your jurisdiction is strictly on the building code, the zoning code, and the municipal land use law. So the International Building Code and whatever other building code requirements Steve is obligated to enforce, that is not something for the jurisdiction of the board, nor can we grant any waivers or variances from those building code requirements. This is strictly what's before the board today is an interpretation regarding if this use is classified as a medical office use. And if the board thinks so, then they would direct Mr. Depkin to issue the zoning permit, which he had issued, but then there were questions regarding the use here, which he rightfully, it is a unique use here in what's going on, where he was well within his right and should have questioned what was going on in that instance and brought it to the board's attention for them to make an interpretation. And what your role is to hear all the testimony of the applicant and decide under the zoning code and municipal land use law, not taking into the account any building code, construction code requirements that they would still be subject to, is from the municipal land use law and zoning code perspective. What is the use that's happening here?
So I'm going to attempt to paraphrase for the public, for the board, because I just want to make sure, and for me, make sure I even understand it correctly. This board can give you the thumbs up and the approval to say, we want to build a trampoline park here. However, we can't exempt you from having smoke detectors. Is that
Yes.
analogous? Is that fair?
Yeah. Once it leaves this board and goes to Steve, Steve has all these other regulations that he has to review it for and it has to comply with. And that's why usually, especially when you see floor plans come to this board, they're like bare bones and it's just a drawing. And then once it goes to Steve in the building department, you'll see all these electrical, like there's all these other requirements, fire code, building code, that those details have to be on there before a use like that gets permitted. So it's not, this board never reviews any of that. And we can't exempt them from any building, fire, construction code requirements. It's not our jurisdiction.
And Chairman, just to piggyback off of that, because I don't disagree with any of Mr. Depkin or Ms. Federico's opinions. I think to piggyback using your hypothetical of a trampoline park, and I had this recently with a pool application elsewhere it was a school site that was adding pool, and then after the approval, then there were a whole bunch of building department considerations on what type of fencing you need, how tall that fencing needs to be around the pool, safety. So again, things that were not necessarily reviewed or needed to be reviewed by in that case it was also the Zoning Board of Adjustment, things that come after the fact. So I think to use your trampoline hypothetical, I think that's a great example of you could approve a trampoline park and the building department could come in after the fact and say, all right, now the netting around each trampoline needs to be this and that, right? So.
Okay. I mean, I feel like we're on the same page here. So then, and I didn't mean to interrupt your opening statement there. If you want to catch us up, or if anyone has a proposal on how we proceed.
Sure. I mean, I do, and
okay.
I'm happy to do so.
Yeah, feel free.
If it pleases the board. So, again, so we were here back in December. We presented testimony on the site and traffic engineering from our engineering professional. We presented operational testimony from Mr. Topper, who's the COO of Golden Care, to detail how the operation operates, and specifically I hope everybody either was here or saw the tape. But again, just to remind everybody that this is for a therapy use for children with developmental disabilities, specifically autism, for care that is clinically diagnosed and a treatment plan provided, and ultimately is paid for by medical insurance, whatever the medical insurance of the individual with the diagnosis is willing to cover based on the treatment plan. So that's a very high-level paraphrasing and reminder as to what the proposed use of the facility at 2 Forest Avenue is. And again, my client is here if there are any other specific operational questions. The one thing that we did, or the main thing that we did, because there was a lot of back and forth from the board, and I hope I'm not overstepping by suggesting something that's not the case, the board did not seem to have what I'll call practical issues with the operations of the site or the building itself. I think the million-dollar question that the board appeared to be struggling with, and the guidance that was given based on that struggle, was what is the use, and is this use truly medical, as was initially approved by Mr. Depkin on the zoning permit, or is it a child care use, as Mr. Depkin then withdrew his zoning permit and determined that it needs to come for child care? And the direction, and that appeared to be the struggle. We ran out of time at, I guess, 10:30 or so, did not have an opportunity to conclude our case. But the parting words that we got from the board is, well, between now and the next meeting, is there any way to solicit any additional guidance from anywhere else, whether it's the state, other municipalities, as to how we should look at this use? And of course, certain things might be precedential, certain things might just be suggestive, and so we did both. So we went and filed OPRA requests with other surrounding Bergen County municipalities. I will preface it by saying every operation is slightly different, so there was nothing that was exactly the same operation that you heard, but the overarching response that we got, there were a couple of sites in Paramus, there was one in Fair Lawn, there were 2 in Ramsey, and the overarching response that we got as to how those municipalities classified ABA therapy uses Some classified them as medical, other classified them as retail/personal service. And there was one site in Paramus that specifically employs childcare operators as well, and specifically has a daycare component that got approval as both a medical facility as well as a child daycare. And that was a very specifically nuanced use difference. The other thing we did, and I would not call those precedential, I would call those informative so that this board has an understanding of how these uses have been viewed. The other thing that we did, which I think would be a lot more precedential, and it was suggested by this board, is there any way to obtain state guidance on this issue? And so we did. So I reached out to the DCA, Department of Community Affairs, with the state, and specifically they have an office on child care licensing. And it took a few presses of different phone keys to get to the right person, but and then of course it was after business hours, so they didn't call me back. But eventually I did, and I had a great conversation with Miss Danley, Kira Danley, who works there, and she said, actually, you've got to the right place because I'm not just in the Office of Child Licensing. I myself review and issue exemption letters for child care licensing when they are appropriate. And she said, you don't have to come to my office if you want to open a child care facility or a facility that may look like there's a child care aspect. But if you'd like a formal exemption so that we don't need to oversee any of your operations, you do have to come to my office for that. And so we did. And it was a little bit, and I confirmed with my team that they were ready and willing and able to do that, because it's a little bit like, I guess to use the adage of Schrodinger's cat, once you file that application and once you reach out, you have to. And it's a whole application where they solicit what information, they want your operational information, they want what you're doing every day, they want your facility details. We provided all of that, and once they give guidance, you can't really undo it. So if they were to come back and say this would be subject to childcare licensing, we would either have to drastically change our operation and reapply, or live with that determination and change a whole significant amount of our proposed operation. They came back in the alternative, and they actually came back. And I did submit the letter to this board. I believe it was listed as your correspondence. I will just, I'm not sure if you'd like to enter it as evidence. I have several copies that I can pass around.
I feel like we might have it on our.
I'm going to pass it around if it's.
I think we actually have it. Is this it?
Yeah, it's dated. It is dated. But it's dated.
January 16th at the bottom underneath the signature?
Yes, correct. January 16th by Miss Danley. That's correct. So I'm going to read, forgetting, the first couple of paragraphs, which are really they're kind of the introduction. Right in the third paragraph, it says, based on the results of our review, the OOL, which is the Office of Licensing, has determined this program does not meet the definition nor the character of a child care center, and therefore does not come under licensure. And this was the guidance that we had hoped to get, and we did in fact get. And the reason I sent this to the board, and I felt it was appropriate, and for full disclosure, I had many conversations, which will be reflected in my billing for certain with my client, with Ms. Federico, and we talked about this, and Ms. Federico and her partner, Mr. Liebman, and we talked about this and said, well, what does this practically do? And the result and the conclusion that we came to, and I'm not going to speak for her, but that we came to is this, as Mr. Depkin had mentioned before, separating out the zoning municipal land use law classification, which is the jurisdiction of this board, from the construction aspect of things, the International Building Code New Jersey edition. This board is tasked with determining what use is this, making that interpretation, and if we fall under the medical/therapy/office use, then it would be a direction to Mr. Depkin to issue or reinstate his zoning permit, after which point he can do whatever he feels appropriate in his capacity as construction official with respect to any permitting and certificates of occupancy. Or does the board feel, despite this direction from the state that would tell us you do not need to license this facility as a child care facility, this board has the right to make the interpretation they still feel, based on the operational presentation that we provided, that this is a child care facility. And if they so determine that, we do have our professional planner to conclude our case and provide testimony with respect to that. The only thing I want to caution the board before I think what I would like to do is ask the board for their determination as to kind of where they feel based on this new information, which I think is very helpful and quite honestly indicative of what it is that we're proposing. I do want to caution the board that now that we have something from the state saying we will not license your program, we do not need to license your program, you do not fall under our licensure, if this board does determine this is a child care facility in the eyes of the 7 people sitting up here, we would run into a situation where we have an approved use at the municipal level, but we will not actually be able to operate because the state will not license us to do so.
Yeah.
So I know I don't mean to hamstring the board, but I actually feel that we did exactly what the board asked, which is try to get that additional information, and this is that additional information. So that's my opening spiel. Beyond that, like I said, if the board would like testimony from a professional planner with respect to a variance, my planner is here this evening and able to do so. If the board would feel, based on an interpretation, that this is in fact not a child care facility and does align more with that medical and therapy use, then they could direct Mr. Depkin to issue the zoning permit, understanding Mr. Depkin has every right in his capacity as construction official to continue to engage with us as to whether the building satisfies what he perceives to be the construction code classification.
That's fair, and thank you for the explanation. I think that reaches all of us. So I know there are a couple of options. I think
If there's anyone here from the public that maybe, before they have something to say, or, I don't know.
yeah, I mean, we can certainly open it to the public. I mean, I don't know if this isn't testimony. I guess we're just getting caught up, really, since it's been a while. And let's hear from the professionals. Is there any thoughts on the new information, the correspondence from the state, everything we've just heard? I know, Steve, you'd let us off, but any new info?
Yeah, I think we're at a good point because I think we've clarified a lot of decisions that everyone has to make. I think what you need to determine next is, with the resolution that was adopted for the construction of the building, what was permitted uses. And it was office spaces and doctors' offices were part of that. If they can incorporate that into their application, showing that that's what it is, then it sounds like it would be a permitted use. I think that I think you need more clarification on that, and then make a decision.
Okay.
Steve, can I just ask you one question? If this is a medical use facility, is so determined, is there any sort of standard in terms of the size of the space versus the amount of people under treatment at any point in time?
Well, that falls under the construction code also. I don't know if there's any medical state codes requiring certain spaces, but I know that other applications for ambulatory surgery centers, things like that, there were professionals coming in to give us that documentation and information.
Okay. Engineering, any thoughts? I know you're new to the case, but that's okay.
From an engineering standpoint, no, I don't have
Okay.
any comments.
Caroline?
Thank you, Mr. Chairman. So I appreciate all the information. I appreciate Mr. Depkin's explanation at the beginning, and as was mentioned, I think that he definitely was looking out for the municipality when he flagged this, and bringing this to the board was definitely the appropriate response. In light of his last comment, I am trying to read the resolution from 1973, which appears was definitely done on a typewriter and is not of the best quality. Appears that there were 2 doctors were the applicants. They seek to a 2-level professional building covering, and it goes on to talks about the parking, And actually, that application went back to 1970. I do, based on the information that's been provided and the testimony also, the testimony from the last hearing and the letter from the state, from a use perspective, via the ordinances and the municipal land use law, it doesn't appear to me that this is a child care center. And even looking at the land use law with respect to child care centers, a certain type of licensing is required. I just had that open. Child care centers, this has to do with a child care center being a permitted use in a non-residential zone, which is not the case here. But a license is required, child care centers for which upon completion, a license is required from the Department of Human Services pursuant to, and then it lists the state law. So that doesn't apply here either, as well as respectfully, with a lot of the testimony we heard at the last time we were all together, it didn't appear to be a child care center either. This is, obviously, at the time in the 70s that this building was approved, I don't think ABA therapy, if it existed, certainly wasn't very prevalent. I don't know the history to know when, if it was being utilized in the 70s. But certainly this perhaps is maybe a newer use that is something that wasn't anticipated or expected within the zoning ordinance, that isn't a child care center.
Yeah.
And isn't maybe, it's
Somewhere in the
question
middle.
is if it's,
Yeah, I don't want to foreshadow, but maybe good segue to Danielle.
Yeah, I just wanted to echo what Caroline stated as well. I have the utmost respect for Mr. Depkin, and I believe given the uniqueness of some of the operations here, he was well within his right and should have flagged this for the board. But in my legal opinion and in consulting with Mark Liebman and consulting with the borough attorney, we were all in agreement that given the testimony that was provided by the applicant, as well as the correspondence from the state, that within the confines of the municipal land use law and the zoning code, that this does not meet the definition of child care center. That being said, the first step for the board tonight is there was the interpretation request made to review this application. Is it a medical office use? If you think it is, again, then you would agree with the applicant, and then you direct Mr. Depkin to issue the zoning permit, and then any construction code requirements are still on the table. The applicant would still be subject to that. The other option is if the board says we don't think it's really a medical office use, we'd like to hear the D1 use variance application that the applicant has also filed. Then I would urge the board in that instance to hear the applicant, hear the testimony. Again, our legal opinion is that this is not a child care center, but I believe I stated at the last meeting as well, if it's something else that it's not contemplated in the zoning code, and because it's something that's not contemplated, that if it's not listed as a permitted use, that automatically triggers a D1 use variance. So they'd still have to put on the proofs for a D1 use variance. But in that instance, as opposed to if you said, yes, it's a child care center, that runs with the land, right? So permitting a child care center here, that runs with the land, and that means it's not, if you find that this is something else, you could tailor it specifically to this use based on the operations that were testified to, as opposed to, I think there was some concerns raised by the board at the last meeting, was if we do allow this blanket use and it's something different, does that create issues down the road, which I completely understand. Again, you have the option to say we actually think it is a medical office building. That's our interpretation, and direct Mr. Depkin accordingly. or it's something else. Again, I would strongly advise you to not find that as a child care center because, like the applicant's attorney stated, it's clear that the state is not going to license it. I think then it creates an issue that if we're saying it's one thing, they can't be licensed, that use can't operate. But is it something else? So.
Could you remind us, is there any guidance around what constitutes medical office under the municipal land use law?
I did look in your borough code. That's also not defined. I'm sure in Moskowitz there's a definition for medical office, which is a generally accepted book of definitions. I can try and pull that up while we're here.
I think I looked and it was pretty bare bones.
Yeah.
Would there also be limitations if this was considered, I don't believe it is, but some sort of group therapy? I think the testimony was, it was all individual, one-to-one, so it wouldn't be. And it's, I guess the only part that I'm still grappling with is the potential number of very young children in one place at one time, even though they're theoretically each individually therapeutically supervised.
So one thing I can add to, and I think it's a good point. You heard the operational testimony that it is one-to-one, right? And at the risk of course, my preference here this evening would be for an interpretation that this does fall under medical, to have the permit issued and go ahead. But at the risk of, quite honestly, what may be actually the better approach for this board, given that you are grappling with this question a little bit, if you took Ms. Federico's approach, right, and said this is ABA therapy, is its own use, it is not explicitly permitted in this zone, or quite frankly in your ordinance, really anywhere, this is a D1 use variance. We would like to hear from your planner to put on proofs about the site suitability or the inherent beneficial nature of the use. We go through that. You can tailor any approval of that use to the exact specific operations that were testified to. And what I mean by that, and I know I said it a couple of times, what I mean by that is you could condition that on this has to remain one adult to one minor. You can condition it on, and I don't have it in front of me, but I could pull it up. There are X number of parking spaces for the square footage that you have. You could condition it on every single one of the operational items that were testified, and the protection that gives you as a board means if Mr. Topper and his company change their operation, even nominally, right? Even said, based on medical advancements or clinical advancements, we can now actually handle one adult for 2 minors. They would need to return to this board to get an approval for that. So I think by going the D1 use variance route and calling it its own thing, you're doing 2 things. One, you're tailoring it to the exact specifications placed on the record and the application that's been presented. And the other thing you're doing is preventing any sort of precedence with any future applications for any future type of use, because such applications would, again, be very, very tailored.
Mm-hmm.
So, again, at the risk of kind of undermining my own argument that this might be an interpretation issue, I'd be remiss if I didn't say I think that's a very valid approach to this.
Yeah, I'd be inclined to agree. And any other board members? Questions on this? Just to get us caught up. I know this isn't testimony. We'll open it to the public just procedurally, just to if there are any additional questions on what we just discussed. But before we do, board.
I have a question for Danielle about precedents.
Yep.
So I think from prior meetings, it was noted that our cases do not create precedents, but would
I think
interpretation here.
I think the precedence issue is if we were to approve that building for daycare use, then any future owner could operate a daycare there. That's the precedence issue.
Okay. So this is not regarding interpreting this use as a medical office. That does not create precedence, like that all future ABA facilities.
I think the building is already approved as a medical office, right, Steve?
Yes.
It's approved for offices, and I'm looking to where it states, and I recall it somewhere, that they did include doctors' offices.
Okay.
As
But-
far as that definition goes, there is no determination in the borough, but I can speak about other applications and other properties and office buildings that have medical use in it, and it's just not a doctor speaking with the client.
Yeah.
There's other fertility clinic that's here, an ambulatory surgery, but that was approved by the board. But others are dentists, things of that nature. So it's not just one-on-one office space. It's a practice.
Okay.
And if I can find it in here somewhere, I'll let you know.
Fair enough. Okay, any other board before we take public questions?
I would tend to agree with you, though. I think as a D1 variance is probably the way to go.
Yeah, D1 variance with a specific use case tailored to the operations of this. Yeah, I mean, that's my inclination now, but.
And Chairman, for the
question.
Yep.
Oh, go ahead.
I'm wondering if we go the other route, if we say this is a doctor's office or medical office, could we recommend to the planning board or council to then further categorize uses in the borough code, and then how would that affect future applications and this application?
So that is something within the jurisdiction of the zoning board when an interpretation is requested. If you found, I think in this instance it's a little different because it's based on specific testimony of this specific use, as opposed to if you were asking for an interpretation if all ABA therapy uses meet the definition of, well, there's no definition, but fall within the category of medical office, which I don't think they're doing here. They're asking for this specific, narrowly tailored application. But if that type of interpretation request was made, it does set a precedent as far as what that interpretation of medical office is under the code. I've seen that done when there's questions or inconsistencies in the zoning ordinance, and then interpretation requests are made. Let's say, for example, sometimes a chart is in a code and it has some calculation of height, but then a board has always interpreted a height a different way, which is also in the code. Then an interpretation request is made. Future applicants are then bound by that.
Yeah.
So that does bind applicants. In this instance, I think it doesn't set a precedent because they're not asking if ABA therapy uses fall in the definition of medical office. They're asking if this specific use with these ratios and that sort of, based on this operation itself, if this qualifies as a medical office in this site. So I think it's different, but yes, it does in, I think what you were asking, which is interpretation requests do impact the zoning ordinance and how they're interpreted. That being said, if there is something that you think needs changed, that's when you request that the council make a change in the ordinance.
To that point, if we go down the route of reviewing for a D1 variance with specific issues on it and are comfortable that at this point in time that it is we're doing the right thing for the town, for the applicant and everyone, and then at that time to ask the planning board for further guidance as to where these type of facilities can be, and then what building code should set precedents for these things going forward.
So our role is not to direct Steve in that instance to make any determination on the building code, construction code for this use. He has to do that separately. So once...
Okay, so that's separate regardless.
Yes, whatever use that the board determines here, when they go to submit to the building department and get their permits, he then reviews it under a different standard of codes, not under the zoning code, not under the MLUL. He has his own standard that we can't give variations for, that we can't give waivers for. We can't say, Steve, ignore the International Building Code or the UCC, anything like that. That's not our role. Our role is very limited to interpreting the zoning code in the borough and under the MLUL.
And one thing I want to add to that, because I think it goes to Mr. Devine's question, and it's a good, and Mr. Leal's question, it's a good one. If you don't feel, the interpretation issue is how you feel right now based on the ordinance, right? It's right now, does this application fit under medical? And you may feel it should theoretically fit under medical, but right now it doesn't. So you could grant the D1 use variance for this use for now and make at the end of the year, you make your recommendations to the governing body, and you could make a recommendation that they formally codify ABA therapy facilities as part of medical, so that going forward such uses do fall under medical, and that's an option as well. But the interpretation issue is, right now, do you feel that based on the operational testimony that's been provided, this does meet medical, or does it meet some other use?
Because that would go specifically to the ratio of student to, whether it's 1 to 1
Right.
or whether
Right.
it's 10 to 1.
Absolutely.
And,
Yes.
Where, that's where, like I said, there may be a little bit of a difference in terms of how you view the same piece.
Right. Absolutely.
Okay. Trusting that the board is good for now, we are going to still talk some more. Let's get public question on this. Let's keep it to just this. We don't need commentary just yet.
Hi, Paul Atsunis, 50 Beverly Road. The facility that you have is for children, correct?
That is correct.
Okay. And what are the ages?
Have to review the testimony that was provided. I believe it's...
I would advise we're only talking about what we just talked about. We're only asking questions about what we just talked about now. Where that was covered in the previous meeting.
Okay, so did we establish that this is not a daycare center?
That's what we're talking about right now.
Well, that's how I'm trying to figure it out. That's why I'm asking the questions.
So Chairman, can I maybe, this portion is, and public comment is certainly appropriate and welcomed.
Yeah.
This is this conversation is a legal step to make for the board to make the determination. Do they interpret this as a medical use, or do they require us to proceed with the remainder of our application for a D1 use variance?
Okay.
That's what this question is. The operations itself have been testified to, and there will be further testimony if the board elects to proceed with a D1. There will be planning testimony to speak to the justifications for this use.
Okay, but in order to decide what it is, shouldn't they discuss what takes place there and how it?
We did. We did do that.
That was prior testimony.
Finished that? Okay.
We covered all that.
All right. I'll reserve for my comments.
All righty. Any other public questions for this recent batch of new info? Okay. Public questions? You got to go by the mic, sorry.
If you could just state your name for the record, please.
Just pull the mic down.
Laura Ahern? Is that all you need?
Yeah, this is just for questions right now.
Yes, okay. I'm sorry, I need to, since it's just restricted to this, I need to find my section that I wanted to ask about. I'm not sure if this is appropriate now based on what you're discussing, so you can let me know. With the prior approval for 2 Forest Ave, there were certain conditions in place that are currently non-compliant. Simple things like there's supposed to be a no street parking sign on, within the area that they can't park on
I
Amelia
hate to
Court.
interrupt. That's not for the board to decide right now.
Okay, all right.
That's an enforcement issue also.
Okay, and also maybe related to this, and again, you can tell me if it's not appropriate. When we applied for a major home upgrade, we had to put a sewer line in, which runs in the back, as does to Forest Ave. We're both back there. We were subject to strict occupancy and infrastructure limitations imposed by the municipality, and I was just wondering if it varies based on which way you guys decide, if that would come into play with this, or is that like a separate subject that wouldn't be?
That was already decided with the resolution and the adoption of the construction of the building, because they had to go into Paramus to hook up to the sewer system.
Okay.
So they got approval for that. So that's all hooked up to the sewer system as it stands now.
So regardless of the max occupancy based on children and the 1-to-1 ratio, it's all still covered under that, and there's no concerns about that? So I'm just thinking there might be a big increase.
I mean, there are there are occupancy limits on the space, and that would have to be complied with.
Gotcha. Okay. All right. I think that's all I had in relation to that. Thank you.
Okay, thank you. Any other public questions for this info? No takers? Okay. All right, we'll close public questions for now. So, this is probably a first in recent history. This is an interpretation request for us. We're essentially making the determination whether to call it a medical facility and call it a day, or ask for the variance to call it something special. Since we know that calling it a child care facility does nobody any favors. I think that's, we understand that that's now not to anyone's advantage.
I think it's evident that the classification for medical office is very vague, and it would be beneficial to hear the testimony from their planner and just hear the application for the D1 variance to see if we can come to a good understanding to our classification for their type of use, which is kind of a hybrid of medical and daycare. So we have to create something new, and it'd be good to hear from the professional that's here.
Sure.
About that testimony.
So, would you entertain making a motion to?
I will make a motion to hear their application for the D1 variance to determine the use and classification for their operation.
Okay.
And could I just make a clarification? So you're making the motion that this is not a medical office use, strictly like medical office use? Okay.
It's a hybrid.
Okay.
Yeah, I think that's fair. So to motion to hear an application for a hybrid use case, taking departing from the definition of a strictly medical office.
Can I clarify one thing with the motion? I wouldn't personally use the word hybrid because that implies it's a mix of the two. I would maybe just say a
special.
Sure.
Undefined, yet undefined.
I don't think it even has to be. I think it's just, does the board think this is medical office or not? And then if it is not medical office, we move on to the second portion.
Okay. Agreed.
So we had a motion.
So we have a motion to not call it a medical office. Is that fair? Okay. Do we have a second?
Second.
All right. Can we do a roll call?
Yeah, let me do a roll call.
Okay, thanks.
Mr. Lau?
Nay.
Excuse me?
No.
Ms. Day?
I agree with the motion.
Mr. Caparell?
Yeah, I agree with the motion.
Mr. Bartlett?
Yes.
Ms. Odinsky?
Yes.
Mr. Devine?
Yes.
And Mr. Santaniello?
Yes. Okay.
So with that, and thank you for the clarification. So with that, I will call up our professional planner, Joe Burgess.
Okay.
And just before we formally do that, I'll just remind the board again that the testimony that's on the record that shall serve as the foundation for Mr. Burgess's planning testimony and justifications.
Sounds good. Thank you.
You have to repeat all that.
Yeah.
And if you could just raise your right hand, do you swear or affirm that any testimony you're about to give tonight is the truth, the whole truth, and nothing but the truth?
I do.
And if you could qualify.
Yes.
Mr. Burgess.
So, Joe, if you could please give the board the benefit of your educational and professional background, what your license is, and the status of that license in the state of New Jersey.
Certainly.
I think you're good. I think we know you for many plenty of history with the board with the
So, Joe,
with
can you
Oradell.
confirm for the record that your license as a professional planner is in good standing here this evening?
Yes, it is.
Have you testified before any other board? I'm just. Yeah, okay.
Just once or
So I would
twice.
submit Mr. Burgess as an expert in the field of professional planning.
Thank you. We certainly accept.
So, I'll try to be brief. This is an application for a full-day child therapy for children with autism. I'm going to skip a lot of this so we can move to the heart of the matter. Let me just touch very briefly on the master plan because that goes into the heart of the statutory burden. The site is actually designated for a single-family residential use. What's interesting is, and I think Carolyn mentioned it earlier, the original application goes back to 1973. And in 1973, they got approval for a professional office and medical use. At that time, this is pre-municipal land use law, which had a major change in 1976. So they then had to actually go to the governing body to get certification of that approval. And I'd quirk back then. In 1986, the planning board gave site plan approval for professional office use again, and now we're here before the board. So when we look at the master plan, although it has kept a single-family residential zoning, which went back prior to 1973, the site has been used since 1986 for the building that you see there today. Now, there's a series of goals and objectives in the master plan. There are three that I would like to highlight because I think they're the most pertinent goals relating to this application. The first is a general goal that talks about encouraging municipal action to guide the appropriate use or development of all land in a way that promotes the public health and general welfare. And we'll talk about that in a minute. Secondly, there's a goal that talks about providing sufficient space and appropriate location for a whole variety of different uses to meet the needs of New Jersey citizens, and that, I believe, would include the needs of children with autism. And then thirdly, there's a goal that talks about promoting facilities and services to meet the needs of borough residents. So the therapy it's available only for children. This therapy is only available for children with autism. There was a question from somebody that asked what age they are. For the most part, they're focusing on children under age 5, although there are a handful of children up to about age 9 or 10 at times. I think there was a lot of discussion about what autism is. You know, it's a developmental disability that results in impaired social skills, communication skills, and abstract reasoning. So while this is not a pure medical issue as you defined it, it certainly is akin to that. What's interesting is that as research in this field has refined our understanding of this disorder, it has resulted in more and more people being diagnosed. And what's interesting is the medical profession is constantly refining this, so as time goes by, it seems more and more children are being identified as having autism. Now, all of that goes back to what I mentioned earlier about the three goals of the master plan that I think are pertinent to this case. Now, the zoning is consistent with what the master plan calls for. The master plan said single-family residential. The site's in an R2 zone, but again, for close to 40 years or over 40 years, the site has been developed for office use. In terms of the statutory criteria, I know the board's familiar with it, so this is more for the public, I guess. There's the so-called positive criteria. One could argue either that the site is particularly suited for this use, or one could argue that the use is an inherently beneficial use, and that alone would satisfy the positive criteria of the statute. Then there's the negative criteria of the statute, which says that you have to show that there's no substantial detriment to the public good, nor is there a substantial impairment to the intent and purpose of the master plan. Now, the municipal land use law does in fact define what an inherently beneficial use is. And it says it's a use which is universally considered of value to the community because it, A, fundamentally serves the public good, and secondly, promotes the general welfare. Now, when you have an inherently beneficial use, if you agree with that, there's this Sika case, Wall Township v. Sika, down in, I guess that's Monmouth County. That's the lead case on this issue. And there was a medical office building. It was denied. Dr. Sika appealed, and the court determined that for inherently beneficial uses, there's a four-part test that should apply to all such uses. You identify the public interest, which is at stake. You identify the significant detriments that may result from the grant of a variance for that use. You have to identify how you could impose reasonable conditions to ameliorate whatever perceived detrimental effects there might be. And then you weigh the positive and the negative criteria, and you determine on balance if there's a substantial impairment to the intent of the zone plan and the master plan of the community. So when we look at that criteria, when we take the first prong of that four-part test, identifying the public interest which is at stake, it's interesting because studies have indicated that nationwide about one child out of every 31 are now being identified as having autism of some sort or another. And what they also find is that in wealthier communities, that percentage is increased. And that kind of makes sense because that's where the money is, so you can take your kids to a doctor and they get identified as such. Bergen County has a very significant demand for the need. New Jersey as a whole has one of the highest rates of autism in the country. And it might be reflective of the fact that we have the second highest income of 50 states in the U.S. So the response here is to emphasize early intervention, and that's what this application is all about. Now, when we look at how the municipal land use law defines inherently beneficial use, we find that the characteristics that I mentioned earlier are really reinforced by all that you had heard as to why, what this application is all about. Now, the second prong of that Sika test is you identify the detrimental effects that a grant of the variance would result in. That was a hard test for me. Usually you'd like to be able to point out some negativity. Usually the issue is traffic, parking, environmental concerns, that sort of thing. None of that really applies here. You heard the traffic testimony that the site can accommodate the traffic volumes and the parking issues. The need for buffers, which you also often have where you have a residential and a non-residential use adjacent to each other, is kind of diminished here because there's no outdoor play space for children. Everything is taking place indoors, so there's no concern about noise from kids playing, if you think that's a problem, noise from kids playing in the backyard of people who live nearby. So when we talk about imposing reasonable conditions to ameliorate some negativity, what I was looking at was the issue of how, based on the testimony, how you can require the timing of people coming with their children to the site. And if you recall, the testimony was that everything is scheduled. Nobody just walks in here. So they have a strong ability to tie in, when somebody arrives on site, so it doesn't conflict with people leaving the property at the same time. So that should diminish the issue of any concern that you have there. There was a second issue that was raised about drop-off from Forest Avenue versus Thank you. I couldn't, my mind went blank for a second. And there was a suggestion that all the drop-off from Forest Avenue be designed in such a way as to minimize any adverse effect on the surrounding traffic. But the important, or most important prong is the last one, which says weigh the positive and the negative criteria and determine on balance if there's a substantial detriment to the public good. I'm not using that word substantial just to throw it in. That's part of the SECA test. And so what are we weighing here? In large measure, I think we're weighing the fact that this is a highly beneficial use based on what you heard from my client and some of the statistics that I just mentioned earlier. So it's a highly beneficial use that serves the public good, and it's tied to public health, since the link to therapy is for autistic children. And you're weighing that benefit against some minor traffic and parking intrusions at limited times of the day that the traffic consultant had touched upon when there was that testimony. So I think when you balance the benefit that accrues from permitting this use versus that minor issue that I just mentioned, I think the balance clearly is in favor of the application.
And Joe, I would just ask on that point, even if you perceive some of those negatives as traffic at a certain time, by imposing the conditions of scheduling the drop-offs and being able to control it, that would also be ameliorating and speak to that prong as well. Is that
Exactly,
right?
exactly. Now, the other issue is the so-called negative criteria. It's a two-pronged test. The first question is there a substantial detriment to the public good? I would say there's a substantial benefit to the public good in light of the fact that we're providing this service that is needed in the community. And then secondly, is there a substantial impairment to the intent of the master plan? And when you look at the three goals of the master plan that I brought up earlier, I think it's clear that from a public health and promoting the general welfare issue, this affirms that goal, as well as the other two goals, which I don't need to repeat again. But suffice it to say that I think both prongs of the negative criteria are affirmed by this application, which enables you to approve this case.
Thank you. And Joe, just to be a couple of things to follow up on, but some of the testimony that Mr. Topper provided was specifically about early intervention and the benefits of early intervention for children with autism. And the earlier that you intervene and provide this critical care, the more likely the outcome is that these children will grow into adults who can be, I hate to use the terminology, but really regular members of society, productive, who operate and function, just like anybody else. And so would you feel that, speaking to the master plan goal as well, which I think you did, would that also play in that this particular use at this particular location and the ability to provide this care at a centralized location for residents of the borough as well as greater Bergen County do actually serve as a positive?
Yeah, no, it's clear from my perspective that it is a very positive feature and something that the municipality could be proud of having in town. There's a lot of benefits in terms of improving the life of these young children and making them productive citizens in our communities. There's really nothing negative substantial, to use the statutory term, in a substantial way that you could identify that should discourage the board from voting for this application.
Thank you. And my only other question is just to really tie a bow on your testimony. You talked about the inherently beneficial. I personally agree. I think that's the right approach to the application. But in the board can also approve a D1 use variance under the more traditional Medici case. So if you could talk about that.
Let's talk first about if you chose to look at it as a D1 particular suitability issue. We have a 12,000 square foot building at a busy corner. It's, you know, an attractive looking office building that's been there for a while. Nobody's going to knock that down to build a single family house, which is what it's zoned for. So you have this building is going to be occupied for some use. The benefit of having this particular use at this particular location is you have a strong ability to control the volume of movement back and forth by virtue of the way they structure their appointments. You would not have that if this was just occupied by a general office, a lawyer's office, or a planner's office. People come and go all the time. The board would have no control over that. So that's a significant issue in terms of particular suitability. In terms of the Medici test, the Medici test basically says it's an enhanced quality of proof where you have to prove that the site is particularly suited for the use, which I kind of just touched upon, and there won't be a substantial impairment to the intent of the master plan, which I had also justified earlier. So I don't have to repeat all that, but suffice it to say, I think the Medici test is, you know, adequately affirmed here.
Okay, and then my last question to you as well, regarding being that the board is taking this application as a D1 use variance, and it's been well talked about that there's clearly no standards for this use within the zone or frankly within the borough of Oradell altogether. As to the testimony with respect to the operations, the testimony with respect to the available and provided parking supply on the site, the testimony with respect to the building's location on the property, and understanding that any variances would be subsumed within this use because there are no standards for this use, do you feel that the benefits of this application would substantially outweigh any detriments and that the relief can be granted for this particular use based on this particular set of facts at this particular site?
Yes, for all the reasons that I've already testified.
Thank you. So I have nothing further from Mr. Burgess.
Okay, thank you very much. Let's hear from our professionals. Steve?
No comments.
No comments?
No comments.
Nothing? Caroline?
Thank you. Very quickly, that
Sure.
was very thorough. I appreciate both of the proofs. I just wanted to add, when you were discussing conditions and you talked about the drop-off being staggered, you mentioned it, but the no outside play area, that was actually a condition that came up as well. That
I think,
so,
that, yeah.
so, and that was so. I just wanted to point that out. That isn't just, that's a condition. So that's another condition to.
Fine.
Right.
Yeah, it's
right.
another mitigating
It's
factor.
another mitigating, and also I even think a member of the public brought up benches or a barbecue or something near the property line, and I think the owner agreed to remove that as well. So that's further conditions. I just wanted to point out that. That there's been other conditions also that I think even.
I don't know if the board made a decision on that one.
The board didn't make a decision? Okay, but the outdoor play area, that was definitely a condition.
Correct.
So there are some other, there were some other factors even further, I think, supporting the testimony that, I just wanted to bring out. And I think that the testimony was very thorough, and I appreciate it. I have no other questions besides that.
Okay, thanks. Danielle?
I have no questions.
Okay. Board? Questions?
I just have just one question. Well, you presented a strong case for inherently beneficial use. Is there anything, because of the type of patients that you're going to see in this facility, that should there be any additional consideration given indoor to additional handicap facilities or any of that, would that any of that, do you feel from a planning perspective, be necessary?
I don't think so, because the issue here is, as I mentioned earlier, communication and the other things that I spoke to. It's not a physical disability.
It's not a physical disability.
And you have handicap parking on site in the plan already.
They need to meet ADA compliance.
It's what?
They need to meet ADA compliance.
Yeah, which it does.
I understand, but compliance, a lot of times for a smaller community, when you figure out the total.
That's based on occupancy, right?
Based on occupancy.
Yes, occupancy, the size of the renovations, yes.
Yeah.
Thank you.
You're welcome.
Other board questions? No? Good.
Maybe just one thing on the parking. So there are 45 spaces, I think, for the
Correct.
entire property. And this facility is going to occupy the first floor of the property.
Correct.
There was some discussion, well, let's just back up for a second. So 45 spaces, you're occupying just the first floor. I think in my notes I have that you think you would probably need 37 spaces at any given point in time, which only leaves 8 spaces for the top floor of the building. And would seem, unless there's some condition that we put on this, would not seem to be, at least on, I don't know, just my rough math, would not seem to be adequate. And parking is a problem. Parking is a problem in town in general, like traffic is a problem, and there is no alternative street parking in the area.
Yeah, let me just address it if that's okay, Ms. Day. One point of correction, I have in my notes, and maybe I'm wrong, but that the testimony was that there were 11 spaces used at the peak time, and it was observed a couple of times. 11 spaces were occupied when our traffic engineer visited the site multiple times. They saw 8 at one point, 7 at another point. 11 was the peak that they saw for the upstairs uses, which are it's a law firm, which, if you know lawyers, we don't go into the office ever. But there's the law firm, and I forget what the other use is up there. But the testimony was that the 34 empty spaces at what was the peak for the other use would be satisfactory, given that we are staggering our drop-off and pick-up. And
Yeah. And I know we've talked about that, but I also have in my notes that the scripts for the students are generally for 30 to 40 hours a week of therapy, which is basically, an 8-hour day, similar to what you would experience. I know we're not calling this a daycare facility, but similar to daycare where people come in at, 8, 9 o'clock, they leave at 4, 5 o'clock. So I hear that there's an ability, but for practical purposes, I'm not really sure how much it would be staggered, right? If most of the scripts are for 30 to 40 hours a week.
Right, by staggered, I mean that the drop-off could be it could be a 9 to 5, which is 8 hours, or it could be a 9:15 to 5:15 slot, or it could be an 8:45 to 4:45 slot. So you staggered in terms of you're not going to have parents all dropping off at exactly 9 o'clock was what the testimony was, and that could be controlled. The other thing, and again, I have this in my notes, the Mr. Topper's testimony was that there would be a maximum of 32 staff, and since we said at 1-to-1, one of those staff would be an operation manager, the other one would be the clinical head.
Right.
So there would be 30 therapists, which implies there can only be 30 kids on premises at any time. So given the traffic engineer's testimony about 34 available spaces at the peak time, the testimony was that it would satisfy. And I think based on the prior resolution, I would have to review it, but I believe there's a condition also that no parking is permitted on the side street over there. I believe that's what I read.
Correct.
So that would obviously remain in effect anyways.
So then the top floor would essentially be limited to about 10 spaces of parking.
So it would actually be, I think, given the math, so 32 plus 11 plus 13 is 45 spaces, which is on the site. So they would be, and because my client is the contract purchaser and would be owning the property, part of the lease agreements they would have with their upstairs tenants would include, whether it's designated parking spaces or just a total number of parking spaces that they're permitted to occupy.
Okay, so we're just so everybody's, thinking about this in the same way. So the bottom floor, right, the facility that we're talking about is 32 spaces max.
Right, that's correct, yeah.
32?
Yeah.
That wouldn't allow for people dropping off, though, so it might be a bit more, right?
So doing some rough math, if we said 11 was peak for the upstairs uses, 45 minus 11 is 34. 32 would be at max capacity of the staff on site,
right.
Which leaves 2 spaces effectively for somebody to come in, drop off, and come out, and that's mitigated by the ability to stagger at, I used 15-minute examples, it could be 3-minute examples, right?
Yeah, okay. All right, and it sounds like you all are open to having these conditions included in approval if we move were to move forward in that way.
That's correct.
Yeah.
Yes.
I have a question just to piggyback off Ms. Day's question, and in addition to, I did have that in my notes as well about the lease. I just want a little clarification as far as in the lease, is it for 11 spaces?
Right now, we're not sure because my clients don't own the property yet, so
Okay.
they're not privy to what the present leases are between the current property owner and the tenants. But as a property owner, I'm sure there's a period of time where there's a turnover where if they're subject to a one-year lease right now, you would have to honor that. But the ability over time to obviously renew or revise those leases would be in my client's power.
But aren't you going to have copies of those leases before you close? Because the property's going to be subject to them.
I would assume so, yes. Yeah.
But we
and
don't know what they say now.
I
That's
do
the
not.
point.
Correct. I do not.
And you're under contract for the upstairs or not yet?
For the entirety of the premises, it's right now. They have a lease right now until I could ask Mr. Topper, but I believe the lease is until such time as there's full unappealable approvals, at which point they have the option to set a closing date and purchase the property.
So we would be, potentially thinking about an approval, on this without the transaction, having been closed, and these conditions, we might not be able to.
Well, they are a tenant right now. They are paying rents to be so just like any applicant doesn't need to be a property owner, they have a property interest currently. I mean, they have a lease. They have fit out the space based on permits that have been received. So they do have a
Plus,
property interest.
Yeah, I was more referring to your ability to control the parking.
But it may be the fact that the program couldn't ramp up. The focus, the therapy program can't fully ramp up until those leases are turned over. And that parking is so stated.
And that's where I think if we give the discretion to work with Mr. Depkin or the board engineer so that it is regulated, because I hate putting a number on it.
Right.
If you don't own the property and I say you have to have leases in place that are restricted to 11, then that's another situation where you have to come back to the board if you don't have the leases. So I would strongly encourage the board to then give Mr. Depkin and the board engineer the discretion to regulate that until the time, impose the condition that it's regulated in the lease, but give them the discretion to regulate that, because I'm concerned if we put a number on it now that they're going to have to come back.
The other reason
They would have to present to the construction official when the program floor can be fully occupied.
Yeah.
Is what you're saying, correct?
I'm saying if we impose a condition that says, as a condition of this, of any approval in the event you guys want to entertain an approval, that it would be subject to restrictions in the lease for the floor above, subject to the discretion of the board engineer and the board and the construction official, that there's sufficient parking on site.
Right, because the other thing I would add to that as well is right now there are parking requirements based on having a law firm upstairs. A law firm is, and Mr. Depkin can probably tell you, whether it's 1 per 200 square feet, whatever the number is, if that law firm turns over to a different use that has a higher parking requirement or a lower parking requirement.
Or it's medical.
Right, which has a higher parking requirement, right, so 1 per 150, I think. So, right, the use would be permitted, but they may run afoul of the available on-site parking. So I think when you have these shared uses, I agree with Ms. Federico. I think it's best you would be granting an approval effectively this evening based on the operation for the up to 32 staff for this facility, contemplating the fact that there are 45 total parking spaces presently. If any of the other uses change hands and have a higher parking requirement, they would either need to seek a variance or go before the board and for some type of site plan approval.
And also subject to, in the future, when you do have control of the property, there being leases in effect that regulate that.
Right.
Because I think that's what the board's looking for.
Right.
I just had one other question with respect to the parking. Is there going to be signage for where the parking is for the upstairs tenants versus where like drop-offs are going to be or employee parking?
So I think drop-offs, we said there would be, but I think just to what we said before, if the count requirement for upstairs changed based on the uses that are there versus what uses are in the future, I'd be worried about signing, these are the 11 spaces, because the requirement could become 8 spaces, the requirement could become 15 spaces. So I think it's probably in the applicant's best interest to identify for their own staff what spots are available versus what's upstairs, but I don't know that making it a formal condition would be beneficial to anybody. But the drop-off, I think, was testified to that would be identified and clearly, because those are not, with staff, you kind of know where your space is. With drop-offs, it should be signed.
Thank you.
And there was testimony that there's going to be there's going to be an employee outside assisting with the whole drop-off.
I think it was
helping,
each drop-off was accompanied.
Correct.
Right? I think it was stated as each drop-off being accompanied by
the staff member. That's the therapist assigned to the individual child being dropped off would know, and they get, it would be by text or phone, and would come out and greet the parent and the child and take the child in.
To refresh my memory, was there a design for the parking and drop-off?
Design, I think the testimony was that there would be clearly signed, these are the 2 drop-off spaces.
So what I'm thinking, are they pulling up to the front door and dropping off, or they're going to be actually parking in a space and someone will come out and get them?
It would be in a space. It would be in one of the 2 spaces. And again, presumably those would be the 2 closest spaces.
Okay.
Yeah.
Okay. Any other board questions? No? Okay, I had questions before, but I think we've covered them with everything so far. Let's pivot to public questions on this testimony only. Okay.
Well, will you have meetings with the parents and the staff?
I don't know if that's for this.
How would you handle the parking when the parents come for those meetings?
So, again, I don't know that that's for this witness.
I don't know that.
Well, it's about parking.
And we had the traffic testimony at the last meeting. I don't have my traffic engineer available tonight.
Yeah, but nobody ever brought up about staff meetings with the parents.
So it's a good question about the parking. We are talking about parking on site. So if there's drop off, we talked about, but yeah, I mean, parents coming for meetings with a therapist.
Right.
Is there going to be an additional need?
Would they be scheduled?
Again, everything would be scheduled, and to the extent that if a meeting was scheduled and it required somebody to park in a public parking space in order to attend that meeting, I'm sure that could happen.
A public parking space.
If somebody needed to park 3 blocks away to come walk to have a meeting with the therapist, I can't tell you it would never happen. Right.
Okay.
There isn't a lot of public parking.
No,
There isn't any public parking.
that's the land
That's why
of no
So you're
public
not permitted
parking.
to park on Amelia Court.
Right.
There's a borough site with the swimming pool.
Right.
I don't know who's policing that, but I would say it's not permitted.
Right.
And there's Paramus. So I
Right.
don't know whether you can regulate that or not.
Right. I would just say it's like if it was a regular office use, right? If someone was throwing an office party and there were people needed parking spaces in addition to what's available.
I mean, there is permitted on-street parking.
Right.
Yeah.
On Ridgewood Avenue?
No.
Or Forest?
Across the street, I think maybe, but it's like you said, it's in Paramus.
Yeah.
Yeah. Okay, we have another public question.
Yes, Laura Ahern. Since we're on the subject of parking, I was going to mention that the original proposal was written so that there's supposed to be signage at 2 Forest explicitly stating people aren't supposed to park on Amelia Court. That was written in, and I was wondering, there is no signage there currently, if that could be brought back up to code or whatever your term is.
Unfortunately, we can't address that here. Like Danielle said, that's an enforcement issue. But Steve acknowledged that that's in the. I think he actually had it up on the screen a little while ago. That is in the old resolution.
I'm not talking about enforcement, but the fact that there's no sign at all, and there was supposed to be.
The lack of a sign's presence is itself an enforcement issue. The sign that's supposed to be there that isn't there, that's enforcement.
So where would be the appropriate place to see if that could happen?
I'll take a look at it.
There you go.
Only because actually living there, I could tell you a lot of people who aren't supposed to park there, park there, and that's just happened. So maybe the sign would help. I do want to say that my husband and I both appreciate the fact that this is a good cause, and we support it in the town. The only reason we're here today is because we're the only resident in a residentially zoned space that is so greatly affected by whatever happens at this office building, because we are directly lined completely up with them and their back parking lot. So in regard to parking, and again, I don't know if this request is appropriate here, but I know the school OPS did it, is that because there's this wait time to have an employee come out and secure the child and bring them in, and other parents lining up possibly while that is taking place, I wondered if we could request that due to the pollution, there's going to be a lot more traffic coming in and out of that area. And again, we're right next door. If it was possible to ask them to turn their engines off so that just the fumes didn't build up as all the parents are waiting in and out. So I just wanted to request that, or just ask it as a good neighborly policy if it can't be enforced.
Steve, do we know how OPS did that, if they did in fact do something to, remind the parents to turn off and not idle their engines?
I'm not aware of it,
tough.
but I know cars have that
Good idea.
option that it shuts off when you stop.
Yeah,
I think
it's a good idea in general,
trying to remove
right?
We were asked to do it when my children attended.
Yeah.
Just a follow-on to the question that we're asking. Since this was originally a residential zoning, is there proper residential versus commercial segregation in there? I mean, because normally the setback...
Fencing and buffer?
Yeah, buffer.
Yeah.
It is in place.
Yes, it is.
Well,
So whatever fence...
It is currently because we put the fence up. It was not put up by the other party. So we own the fence.
Yeah, didn't you ask to put it up? And
We did. Yeah. It's already breaking down a bit, unfortunately.
It's been that long?
But I mean, should that be a condition of that the owners of the building should be maintaining that, no?
Yes.
The other request is that there was supposed to be a buffer, and it's really, I'm sure they put it up originally, it's really thinned out. It was like pine trees. So regarding the perceived value of my property, when we, go to sell in our own enjoyment of the property, my husband and I both work from home. So we've had past tenants be so loud that I can't even sit in my own backyard. I've had to go inside, can't take a meeting or can't take a phone call. And visually, I have a bird's eye view of the front door where all this will be happening. I was wondering if it's possible to replenish that area with like a couple more pine trees, just to kind of have that visual buffer and barrier. I would consider doing it myself, but I have some very mature trees in the yard, and I'm not sure they're going to survive if I plant them there, although we may make an attempt.
Could be part of the resolution.
I think the issue though is they're not the owners yet.
Yeah, you can't.
So maybe the best
Well,
suggestion.
I could enforce it because that was
It's already
a,
on the, yeah.
that was one of the requirements for, the construction of the building.
Yeah, I mean, they could...
And it needs to be maintained.
Maintained because of the change in their tenant, even if gentleman isn't able to buy the building, he still has a right to operate the building, and the landlord should comply with it in order to do it.
I think I heard you already address that I wasn't quite sure I understood the wording, that the barbecue and bench will be removed from the area. I think I heard that. Is that right?
Barbecue, I don't know about the bench. I mean,
It's not their building right now, so they definitely don't have the right to do that. And if they don't end up closing on the purchase and they end up just remaining a tenant, again, they wouldn't have the right to remove property from the premises.
Okay, but the barbecue is not
Again,
supposed to.
I don't know.
I could mention that either way.
Okay. My concern there is it gets very dry. It's literally inches from the woods, and one spark, and we have kids cutting through.
I can take care
and
of it.
hanging out there that have access
so I think that's
to
a
it.
building. I mean, if Mr. Duffin
Zoning.
Thank
has
you.
an issue with the barbecue.
Okay,
but-
no problem with that then. Sorry, I had to rewrite everything because there was a big shift in what was happening. Oh, and the other thing I think I heard is you said that there would be no playground outside.
Correct.
I know there's play area inside for the kids, which is great.
Correct.
I appreciate that because, again, just, it is a residential area. And I am very in favor of this, just a little hard at times to deal with some of the things we've had to experience with previous tenants. And I think that's really it. Thank you.
Thank you.
For your time. Oh, I'm sorry. I did have one more thing. The letter we received recently, and I'm sure you guys will take care of this, but I did have a question about it. The third paragraph for the notice of public hearing says the applicant seeks additional deviations, exceptions, design waivers, submission waivers, variances, conditional use variances, interpretations, exceptions, and the continuations of any pre-existing non-conforming conditions and modifications, and that it sounds like they're asking that it would not have to be re-reviewed.
I can address that. That is a standard condition.
Yeah.
I put that in every notice. If you don't have that, if something comes up, you're automatically kicked. So that's a standard condition all land use attorneys put in their notice.
Okay, but does that mean that if this is agreed upon?
No.
What that means
I
is
think
if
I might have
Mr.
misunderstood
Depkin
it.
or the engineer or the planner raised some variance or waiver that wasn't anticipated, that they don't have to renotice. It was already included. It's a catch-all. It's a standard. I put it in every notice.
Sometimes during the course of an application, conversation will lead to, oh, you need another variance for that. That clause just prevents them from having to start all over.
And I would say it's malpractice if it's not in there. So if as a land use attorney, if you didn't have that in there, you're doing a disservice to your client.
So does that mean if they do want to put a playground in, they would not need to apply for a variance?
It just means if anything came up during the pendency of this application, if Ms. Ryder said, oh, I just noticed you also need a variance for, I don't know, some lighting you're installing, for example, we would be able to proceed with the application because of that catch-all paragraph.
Or also if they said, we'd prefer for you to take out a parking space, but now you need a parking variance. That prevents them from having to come back. It's
They still need approval for everything, but so it's not a free pass to do whatever they want. It's just it covers any variances that come up during the course of the application. Again, requiring approval.
Okay, thank you for the clarification. So just want to note that we're happy to be neighbors. We'll be good, respectful neighbors, and just hope you understand that living next to a residence, to try to, work as well with us as we will with you. Thanks.
Okay. Public questions. Questions again for the planning testimony.
So yeah, I guess it's not really just a comment on anything.
There'll be a comment section afterwards.
Got it. So I understand. Oh, sorry, John Ahern of Amelia Court. Just so I understand what you were saying about the planning, and I understand it's inherently beneficial and everything else, but if the board goes with the D1 use variance, you're willing to put in and agree to these conditions about the busing and all that stuff? And no busing and the parking and the hour, all that stuff that...
Yeah, actually, it would apply whether it was a D1 or the D2. I mean, the inherently beneficial or the particular suitability argument.
Got it.
Those conditions would still apply.
Okay, thank you.
Okay, any other public questions for planning testimony only? No? Okay, we'll close public questions. Remind me, so any other testimony? Or
That's it for testimony. I would just respectfully request the right to sum up at
Sure.
the conclusion if necessary.
Should we sum up first? Should we public comment first? What?
Yeah, I
Remind
would
me
have
the order.
public comment. And
Public comment?
anyone that wants to come up, I'll swear them in. And then
Okay.
you guys can deliberate, or the applicant's attorney could have a summation.
Okay. All right, let's go with public comment.
And again, any member of the public that comes up, I'm going to ask you to raise your right hand, and I'm going to swear you in. You could just raise your right hand. Do you swear or affirm that any testimony you're about to give is the truth, the whole truth,
Yes.
and nothing but the truth? Please state your name and spell your last name for the record.
Paul Latsunas, Latsounas. Before, when I got up, I wanted to ask you, and I think this is the right time now, and that's what we're going to call the building, or what type of building it's going to be. Now, we're deciding here whether it's going to be a daycare center. Is that it?
No, the determination, I mean, I'll let
And
Mr.
Paul, we're not doing questions now. We're just doing comments, you know.
Okay, well, if it's what I would consider a daycare center would be something there, just drop kids off and pick them up, and they play there and stuff like that. But this is different, and this is something for medical, I understand. So I think it should be called a medical building. And the fact that you're going to have, I assume you're going to have some kind of doctors there. And also, when the kids come back, and, they're going to have their parents there, and I feel that the parents need to ask questions and stuff, so they have to park. And I think that that's going to create more parking, and I don't know if you have enough parking for all of that. I think you have probably, I don't know, I'm guessing 15 to 20 children there. I don't know if I'm right or wrong, but that's quite a lot of people, you know, including also the parking, the additional parking, because you're going to have your people that work there, right? And just make sure that you have enough parking for them, that's all.
Okay, thank you. Next up.
Hello.
Hi.
I'm
If you
Linda
could just-
DeSantis, and I am the Realtor for the
I
current...
hate to interrupt you. If you could just raise your right hand.
Oh, sorry.
Do you swear or affirm that any testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
If you could state your name, spell your last name for the record.
Linda DeSantis. I am the Realtor for the sellers of the building right now, and also the tenants for the building right now. And Mr. Depkin is my best friend, because as Realtors, we always go to the building department. So when I was taking the listing, I do my due diligence, and I, of course, asked the owners, what is this property, right? So we went back, we looked back when it was built, and Paul Senior Giblin and, you know, Brian's looking through paperwork, like, yeah, it's office, but I know it was like for doctors or something. So like it was somewhere in there, but it wasn't specific. I said, well, if I'm going to take this listing, I want to be able to do my best job and get somebody and know what we can have in there to not go to the zoning and have a big problem. So with that being said, on April 5th, 2024, the current owners of 2 Forest Avenue Associates hired the Giblins to put in an application for medical. It was approved. And it says also no parking on Amelia Court, just so you know. That's always stated. So that totally is always relevant. So that was for sure. The application was approved on April 5th, 2024. I took the listing, advertised it. It could be zoned for medical, office. People came, Montessori, Apple School, everyone for school. I said, you know what? We went back and we spoke. It might be a problem, but if you go through zoning board of adjustment, anything is possible. We never got that far with those particular clients. Then I met a Kiva Topper. And I said, well, look, it's approved. I have it right here for medical, but you don't fall under medical. So I said in October, I think of 2024, when we first started this, I put in an application, and again, it was approved by Stephen Deptkin for children's autism therapy. So that was all from the way beginning. So when in September of 2025, when finally your build-out was ready and getting your certificate of occupancy, the fire inspector said, oh, this is a school. We can't give you a CO. And he goes, oh, actually, it's medical. Well, we are medical. So it was really inconclusive, right, from September for them and putting them all through this time and money. And I just think a lot of it is really irrelevant, but you found out the right information. We said, go to the state, and you cannot be a school. So I'm just saying, for myself, please give leniency. It's been a long haul. It's for a good reason, a good school.
Thank you.
Well,
okay.
thank you.
Any other public comment? Okay.
You could just raise your right hand. Do you swear or affirm that any testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
And if you could state your name and spell your last name for the record.
John Ahern, Ahern. Yeah, as far as this situation goes, I'm glad the council approved it as a D1 use variance, because I think it is something newer and different than what was originally intended, and I agree that it's beneficial to the society and everything else. But I just want to make sure that you're addressing the concerns and you have safeguards in place, because this facility, like the other facility that we were talking about earlier, can change hands over time. And the way that they do things now may not be the way that things are done in the future. So I just want to make sure that the things are spelled out regarding, the busing, they don't know busing, or anything that you feel is appropriate for parking or traffic protections, the hours of operation, drop off, no outside play area, all those kind of things. So as a resident who lives next door to it, I just want to just make sure that those safeguards are in place, not only for now, for the way you guys work, but for the future. That's all I wanted to add.
Thank you.
Thank you.
Okay. Anyone else? Public comment? All right. We will close it for public comment. If you'd like to sum up, then we'll deliberate and look for a motion.
Sure. Thank you, Chairman. I'll be extremely brief. This is a new one for me. I mean, having gone through the motions on this application, which what came to me initially as something that I looked at and said, well, you have a zoning permit for medical use. You put on the permit application exactly what you're doing, and only after the fact was it determined that maybe this isn't a typical medical use, and it was whether it was called childcare or just something else. Going through these motions, dealing with the state, working with your professionals to come up with the answer to this problem, I think is a testament to how the land use process is supposed to go, right? It's not meant to be an adversarial process. It's meant to be a process whereby we just get it right. And if the use fits and it's appropriate for the property, then we figure out what's the mechanism to get it there and to ultimately have that use operate. I won't go through a full summary of all the testimony, but you heard from our site and traffic engineer, you heard from our operator, you heard from our planner that ultimately this is an inherently beneficial use. I'm not an expert on the statistics, but clearly there are experts who have testified to that fact, and this is a need. There are children with autism that studies have shown the earlier you intervene and the better that intervention is, has a sincere impact on these children's ability to grow into adults that are productive members of society, and that varies. There are some children who are higher functioning, some children who are lower functioning, and you heard from Mr. Topper that right now servicing those children in their homes is great, but being able to do it at a facility that's built out to accommodate this exact unique disorder, but the ability to provide care for that and critical skills for that is going to make a monumental impact. So with that, I think the board has done its due diligence, and Mr. Depkin's done his due diligence in getting us to this state. We have an application for a D1 use variance, and I would respectfully submit that through Mr. Burgess and the operational testimony that has been provided and that will ultimately serve as a condition for any approval here tonight, that we have met our burden of proof for the granting of this variance. So thank you very much.
Okay, thank you. Let's hear from the board with our deliberations. Vincent, if you want to kick us off.
Yeah, I think the applicant has satisfied the burden of proof for the inherently beneficial nature of the use, and with the proposed conditions to minimize the detriments to the public.
Okay.
Yeah, so I think it's. I don't see any issues with this application.
Thanks. Kevin?
Council, thank you for your testimony. I had one concern at the previous meeting, which is about the license. Your paper answered it. So I'm good. I'll leave it to the rest of the board for their comments.
Thank you.
Again, I think the case for beneficial use is there. I do believe that, with the conditions of, we're going to have some level of conditions on here, because I do have concern of traffic flow because it's extremely busy intersection. But just, any D1 variance I would think would have to include, specific in writing of no outside use of the facilities, no food service being brought or there other than what people come in with and leave with, would have to be in there. And that because of the high volume of type of therapy students, that it's always a one-to-one situation that would have to be maintained. As for the number of drop-offs per hour, specifically during the rush hour, I think is something that, we have to come to a compromise on, because I'm not sure if you've ever been in this intersection or around the building. It's tough. And, it's just like I said, if we have more traffic backed up trying to get in. So, I don't know what the right numbers are to propose per hourly drop-off, but I think we need to have them. Because I said if this was a regular medical building, the amount of doctors in there, I think there would probably be a smaller occupancy allowed.
So are you requesting like a schedule of?
I think we need to have that. Just knowing the intersection, knowing the neighborhood, the risks of people coming in off of Forest in the wrong direction, the backup on Ridgewood Avenue every morning, because again, you're dealing with, 3 blocks away to the west is the county school system. 1 block is a Catholic, to the north is the Catholic school system, and inherently during this time, it's just, not your problem. It's an overall town problem, but it's an issue that we would, need to consider. And then obviously the conditions that we talked about on the lease of gaining all of the property, and whether or not we need a ramp up period in terms of total students until we get that, and or how we would kind of just work with you to get it, fully up to speed and all, and in an enforceable manner, not to affect the residents on it. And then lastly, on the current owners of the building, if there's making sure that buffer to the residential neighborhood is maintained properly.
I have that.
Okay.
That's all going to be in the resolution.
The one thing I would like to offer is I've seen, just like there's a review sometimes on lighting, like a 6-month review, where the applicant's testimony is that they believe they could self-regulate this and that all the drop-offs would be scheduled, and that I think in this instance, I think it would be appropriate and reasonable for the board that there be like a 6-month review period from the issuance of any building permit or like CO, that Mr. Depkin has the discretion to, that the applicant has to work with Mr. Depkin in the event there's issues that arise.
Well, not me again.
And schedule it. I figured you'd like the ability to enforce it. Just so that it doesn't, we don't have to come back here. You could work with the building department, and if there's issues that arise, come up with a schedule that makes everyone happy.
Right.
And have a 6-month review, so that it's not neighbors being concerned, calling Mr. Depkin not being able to enforce it. It gives that buffer.
Yeah, it makes sense.
And that would include also, I mean, there's probably going to potentially be need for additional lighting at night in the winter, that it makes the code of not shining it to people.
Well, what's existing is existing.
For professional, and for
I
professional.
don't think we spoke anything about lighting.
Nothing has been requested.
Okay.
Keep your
if
headlights
there's
on.
lights shining over the property line, that's something that I can address.
Thank you.
Okay. Jeanette?
I think I agree with everything that's been said so far. I guess also as far as the use itself, in this letter from the state, they said that the program information revealed children and adolescents ages 2 through 18 only attend scheduled plan-based therapy sessions. I mean, obviously we want the use to be limited to the autism, and treatment of autism for that age group, so that it's clear that, there cannot be any, in addition to it being one-to-one, it should be that specific. I don't know when anybody has any thought about that, but. And the parking is a concern, on the one hand, they say, well, we know that the 7 spaces are being currently used, but we don't know what's in the leases. I find that a little troubling, that there's a little, you say you know what you need, but you don't know what's in the leases that are currently in effect. So I find that a little, I would think you would need to know that to make these statements. But you're telling us you're going to need maximum 32, and that facility can handle it?
Okay. Carla?
Not too much to add. Thanks for the presentation. I think it does meet. I just, in the resolution, because I don't know what we're going to call this, whether it's autism therapy or whatever the proper name is, but I think we need to give it a name. This is specific to this use, whatever this use is that we're going to determine, and not leave it kind of open-ended or amorphous.
Yeah, 100%.
Everything else I agree with. I just don't know how you, Danielle, I leave it up to you. You guys can work together on that, but I'd like to see the use called something.
Maureen?
So maybe a question so it seems like we're moving to a place where we're going to vote, right, in a minute or two, but there also seems to be a lot of, assuming we move forward or we vote one way or another, let's say in the positive, just a tremendous number of conditions. Do we need to put pen to paper on them first before we vote on this, or what's your recommendation?
There are a number of conditions, and I have some of them written down. I have all the testimony written down as far as the operations. I intend to have a resolution drafted in advance of the next meeting, and I think then the board can add any additions if there's anything that comes up. I don't want to rattle off things right now and miss one, because there are extensive operations testimony that is going to be tied to this specific use.
Right.
So I would just offer that I get the resolution to the board as well in advance as possible. You guys can comment on it, send me comments via email or, in a red line or whatever, and I can incorporate those. And if something comes up at the hearing in the event you guys approve this and the resolution's on for adoption, you could also impose that and say, no, I thought we had an additional that I think is perfectly, there's no issue with that.
And
I
we
just
have
don't
the
want to miss
recordings,
something now.
Right.
The recordings, I think we've been, particularly with this application, we've been pretty good about using the microphones when we should. So everything should be preserved, so we can go back. I've been writing down conditions of approval, but sorry, Maureen, anything else you wanted to comment on?
So I think my thoughts, have been pretty well said by the rest of the board members. I think it is a very, very helpful, very beneficial. I appreciate the fact that the applicant appears to genuinely want to also work with the town and its residents to find a solution that works for them and also for us, including, I thought the applicant, their professionals were very thorough, responded to our questions and want for additional information and research, and proposed something, as I said before, that seems to be balanced and is trying to make everybody happy, you know.
Yeah. Great. Yeah, I agree with everything that's been said. I think that this is, you know, like other buildings in Oradell, you know, where we're seeing a lot of new use cases come up, or expansion of different use cases, where you have a non-residential building stuck in the middle of residential, and that's becoming less and less unique. And I think it goes a long way for people to see that you're not just trying to open a business, you're looking to be a good neighbor. You know, and I think that you know, that lands with me. And of course, I think the use case itself is you know, meets the inherently beneficial standard. So that being said, I'm fine with asking for a motion, but as Carlo pointed out, and you know, we've kind of been discussing here, we need to be very specific if someone's going to make a motion in either direction. But I kind of get a sense for the direction we're headed. Of what do we need to call this something now?
Yes,
Yeah.
I think we do. I would like to offer to the board, with their input, of course, that what I have drafted right now is ABA one-to-one therapy for persons aged 2 to 18 years with autism. Because I have an issue calling it children and adolescents. If you have one person that's 18, that's an adult to me.
Mm-hmm.
So that's why I said persons aged 2 to 18 years with autism.
And would that satisfy the, you know, since we took medical facility off the table and we took child care off the table, would that be what we call it?
That's what I would
okay.
call it.
All right, I'm just trying to make sure I get the terminology correct.
I mean, apparently they made a representation to the state in getting this letter.
Yes.
As far as what it is.
Yes.
In the second paragraph.
My only point that I have
Just the word
is
children and adolescents.
I'm not saying to change what
because 18 you're an adult.
Suggesting. I'm just saying we have a kind of an idea of what we
Correct.
call it in that letter.
Yep.
What does ABA stand for again?
Applied Behavioral Analysis.
Applied Behavioral Analysis.
Okay. So then, that being said, would anyone like to make a motion in either direction? Now, this is okay.
Under CAL number 894-25, that we grant the D1 use variance for, Danielle, help me out?
The Applied Behavioral Analysis one-to-one therapy for persons aged 2 to 18 years with autism. Use.
What she said.
With all of the conditions that were discussed tonight, and any conditions that Danielle comes up with through her review of the testimony that's been given.
Okay. We have a motion. Do we have a second?
I'll second the motion.
Okay. Can we do a roll call?
Yep. So everybody's a full member?
Yes.
So it's Mr. Lau?
Yes.
Ms. Day?
Yes.
Mr. Camporelli?
Yes.
Mr. Bartlett?
Yes.
Ms. Odinsky?
Yes.
Mr. Devine? Yes. And Mr. Santaniello?
Yes.
Thank you very much, everybody.
Thank you. And really, thank you to yourselves, the applicant, our professionals, for really figuring out how to navigate this, quite frankly, unprecedented new way to use a building in Oradell.
Maybe we'll get a write-up in next year's Cox.
Maybe.
I'll take you.
Thank you, everybody.
Thank you. All right, we have a little bit of business to cover, so if you're going to leave, we will have open public comment soon. We just have a couple of business items to cover. So if you're going to leave, please leave quietly. Any old business? Old business, the only thing, I'll keep mentioning it until we hit the deadline. The cybersecurity thing is due March 30th. If you haven't, just take a look at your Oradell email. If you haven't gotten the cybersecurity thing, speak with Borough Clerk. Is that correct?
That one, yes.
Borough Clerk. Okay. Any other old business? New business, annual report. So, we received in our packets today the annual report. It looked really pretty thorough. I believe it covered all of the cases that we heard in 2025. Danielle, anything we should know about the wording of the annual report?
No, it's a requirement that we provide this report and then it's transmitted to the mayor and council. It does, because I worked with Gabby, it does include the prior board attorney's resolutions.
Okay.
So all that was captured in this. That's pretty straightforward, unless you guys have any questions on it.
So this is the end of my first full year in this role. If I remember correctly, I think that this would be where we would submit any recommendations to the mayor and council for ordinance changes. I don't know. I mean, we actually spoke about one before that we could potentially include in next year's annual report. I forgot what it was. Just the redefinition of medical use facility. We don't have to try and cram that in here, but are there any, based on the caseload from last year, does anyone have any reason why we should pause and submit a suggestion to the mayor and council about an ordinance change? No. Okay. Then in that case, would anyone feel like making a motion to approve the resolution adopting the 2025 annual report as we have on our desks?
I'll make a motion, we approve it.
Oh. All right. Do we have a second?
I'll second.
Can we voice vote this? Okay. All in favor?
Aye.
Aye. Any opposed? All right. It passes. All right. Yeah, everyone moved. Oh, no, Warren is not here. All right. Vincent, if you don't mind. You got a pen? Okay. All right. That's it for new business. We can be open to public comment. I don't know, Sam, if you want to say anything. Otherwise,
I do, yes.
You do? Okay.
Sam Tripsis, 327 Maple Avenue. What I see here tonight is what I'd like to see in the zoning board. I said you're 100% professional, you engage, you ask questions, everybody, and you explain your vote. I don't always see that. I don't see it in the planning board, which brings me to the next, about joining a board, joining the two boards. The planning board, I think, is weak. They don't ask questions, and I'm going to say it. It's I feel that you might have people that are on that aren't that interested, so they're there, and they don't explain themselves. So
That's your opinion.
well, I'm the.
It's your opinion.
Okay, I'm the public.
Okay.
You know, 36 years of being in the public gives me something.
It's your opinion.
Okay, all right. You covered. I live on Maple Avenue, and like tonight's application, that this was not a compatible zoning. You know, where you're residential and you're commercial. That's what it is on Maple. All the houses on Maple are abutting Kindercomack Road. So what we've had in the past, we don't have good neighbors. We had better neighbors years ago, but you know, when the properties change hands, sometimes they wind up cutting your buffer down. The buffer is very important. You know, it's sound. It's a sound, noise, wind, light, everything. and lighting is covered in that. So we've kind of lost something over the last few years. So I'd like to see that covered. And not go by the wayside. Very sensitive to that, and as a long 36 years as a resident, I've enjoyed it. They call it quiet possession, I believe, but I don't feel that way in recent years. So anyway, I just want to close with this. I'm very pleased to see how this turned out and how you behaved, how you performed. Behaving is the wrong word, but thank you very much.
Thanks, Sam.
Thank you.
Thanks. Sam actually brings up a good point that I forgot to mention during our new business. Just a quick heads up to we don't have to spend a lot of time on it. As you might have heard, there is a request by the mayor and council to have a draft ordinance combining the land use boards. So we may see a time in the near future where the zoning and planning board are recreated into one combined joint use land use board. I'm not lodging an opinion on that. I attended a couple of meetings, asked a bunch of questions, got some answers. If you're interested in that process, obviously feel free to attend the mayor and council meetings. However, what I have been asked for this group to contemplate, you don't have to answer on public record. You can think about it, let me know, let the mayor know. If you're interested, should there be a joint land use board, if you're interested in being on it. So give it some thought. Let me or someone know, and we'll go forward from there. That's it. That being said, do we have a motion to adjourn?
So moved.
Second?
Second.
All right. All in favor?
Aye.
Aye. Opposed? Have a wonderful evening. Thank you, everyone.
Aye.